Sir, you're charged with especially aggravated kidnapping. You're also charged with aggravated assault, and you're charged with theft of a firearm worth less than $2,500.
You're talking about stuff that is not
You will
real.
bring the jury.
Hello and welcome to the Court of Public Opinion. I am the Recovery Addict, and boy do I have a case for you today.
Why is the dog chewing on this guy?
I think they have got the wrong guy
They
there.
got the wrong guy, and the dog was biting him.
He roughing him up quite a bit. There's a lawsuit.
9 out of 10 judges prefer watching the Recovery Addict live stream in their courtroom.
The fireworks are not done.
Now we're getting commentary on the cable. Dati mihi Anglican por service Latino.
That's literally not true.
I didn't ask you to interrupt me.
Is that correct?
Oh, for crumb's sake.
All right, welcome back to the Court of Public Opinion. I am the Recovery Addict. Wonderful to be with you. Had a fabulous lunch. How about you? I did not have Sam's Club sushi or Publix chicken or any of the other wonderful things that we talked about before. I had salad. I was good. And because I had salad and was, sticking to my diet, I finished it off with an ice cream sandwich. So I think it all works out in the end, right? Anyway, no nap. I actually had to run over and help the neighbor across the street fix his TV. And then we're back, so. Anyone, is Alec Murdoch Clerk's trial online? Can I go back and watch it? Becky? I thought she pled guilty. I don't remember if there was a trial for Clerk Becky. I'm sure there was, but there was no trial. I mean, there were hearings. There's the one hearing, I think we did even. We covered that where the jurors were all brought in and everything, but that wasn't really her. Yeah, she pled. He's suing her. Oh, great. Like, what good is that going to do? All right, welcome back. Welcome back. We've got a minute before we go back to Judge Boyd's channel, and before we do, I thought we'd jump in because Judge Dad is giving some marital advice, some marital status advice just now. And why not? Why not jump over to him and have him explain this in this next case about marital advice? This is quick. Listen close.
Granite Tel Valley versus Shannon Allen Woolsey. 2602034.
Garrett Levine for the plaintiff. See Miss Woolsey.
What's your name, ma'am?
Jessica Woolsey.
Wait a minute. Keep your voice up nice and loud. I got a Shannon Woolsey is the party.
Correct. Shannon's my husband. He no longer lives in the home. He hasn't lived in my home in over a year. So it's me.
All right. Was this a first hearing? Did you listen to and understand the rights?
Yeah, I know them.
Yeah.
I filled out an SCR. I'm just waiting for a response.
Okay. All right. So.
Hang on. A year? Hasn't lived in the home for a year. How's this working?
We keep this on track with the June 1st date, 10 a.m.
Yeah, I'll do that. I would have given you the other one. I adjourned to May, June 1. At what time again, Jen? 10?
10 a.m. Yes, Your Honor.
So I'll just, Jessica Woolsey was here, and husband is Shannon. Are you guys separated or divorced?
No, we just aren't together anymore.
Explain.
He lives in a whole different home with his new girlfriend. Like, we don't pay our bills together or anything together.
I know, but are you still legally married?
Yes.
I might want to think about changing that. You do what you want, but that's up to you.
I know.
Okay? So we'll see you here. You'll be in front of Judge Hudson on June 1 at
Cut
10.
loose on the dead weight, he says.
Thank you.
Thank you.
Granite Tel Valley versus Christopher Johnson.
Right. We're done. That's it. You might want to think about changing that. All right. We're waiting to go back to Judge Boyd's courtroom for continuation of this case. Out of San Antonio, Texas. She is not live just yet, so it might just be a minute. That was funny. All right. Oh, I forgot to appear again. Who won the internet? Somebody has to fess up to this. And let's see. Yes, KPE Media. You got your answer there. But Alec Murdoch is still in custody because he did plead guilty to all the financial stuff on the federal side. And you pinned it. Oh, He made it perfectly easy for me. Thank you. Thank you, Josh. Fran Fitzgerald, congratulations. You won the internet. Everything IP related worldwide is your responsibility. There we go. Fran, once again, you are the winner. Or, as we think around here, the loser. Because now you have to take care of the internet for everybody. But, Fran, thank you very much. Appreciate you doing the hard work. All right. Not really sure if Judge Boyd is going to take a long lunch or a short lunch, so we're going to have to sort of keep an eye on her channel. Might pop in on a couple others while we're waiting here. Judge Simmons, we've been there for a while. Let's see.
Your Honor, I've been in Texas.
He's going to be scheduled for a show cause soon because gave him until the 29th to pay these other two before they send the file to me for me to be a bill collector.
Jesse, how much of that can you pay via credit card or something like that today?
No, not today. I can tomorrow. I can try to come in there and make a payment tomorrow.
Of how much?
$50.
Okay, you're gonna pay that on either the careless or the no proof, I'm sure, because that's already waiting for payment. And then I'll note that you have entered the payment plan on this. If you come in and do that, that will prevent those files from going to bench warrant status or having to have a show cause. If you don't do it, you gotta contact the court for an extension, okay?
Okay. I can do that. Thank you, Your Honor.
Okay, and so he's going to plead guilty to no, officer?
The offer was to plea as charged with a cooperative time served because it was our understanding there was time on this.
Good. Okay, raise your right hand, sir. Do you solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury?
I do.
You can put your hand down. Okay, in this matter of driving while license is suspended, you have the presumption of innocence. You have the right to proceed to jury trial and require that the city prove each element of the charge beyond a reasonable doubt. You have the right to remain silent and not have the silence be used against you, or you can waive silence and testify at trial if you like. You have the right to see, hear, or question any witness called to testify against you, and the right to subpoena witnesses that will give testimony on your behalf. Do you understand each of those rights, sir?
Yes, I do.
Tomorrow.
And are you willing to waive each of those rights to plead guilty?
I am.
Tomorrow we also have a Tyler Robinson
you to
hearing.
get you to do that?
No, Your Honor.
Any promises being extended to you to get you to plead guilty?
No.
As to driving while license is suspended, how do you plead?
Guilty.
Factual basis, counsel.
Thank you, Your Honor. Mr. Morales, I want to take you back to on or about April 25th of 2020 on the intersection of Indiana Avenue and Taft Street. Is that in the city of Lansing, Ingham County, state of Michigan?
Correct.
And at that time, were you driving a vehicle?
I was.
All right. And did you have a valid driver's license at that time?
I did not.
And there was police contact due to a accident, is that correct?
Correct.
Thank you, Your Honor.
The city satisfied with factual basis, Your Honor.
The court is also satisfied with the factual basis. I'll accept your plea. I find your plea to be freely, voluntarily, and intelligently made. We'll get credit time served on this file. I'll note that he's going to make a payment of $50 this week. He'll make a payment of no less than $50 per month until paid in full. Any additional matters?
No, Your Honor. Thank you.
Nothing for the defense, Your Honor. Thank you.
Mr. Morales, are you still there?
Okay, we're going to jump from this one.
That's a hearing that's held here in the district court within 21 days. At that hearing, the prosecutor will be required to prove two things. One, probable cause that these crimes had occurred, and two, probable cause that you were the person who had committed the offenses. If the prosecution is not able to do that, the case would be dismissed. But if they are able to, you'd be ordered to stand trial in circuit court. Prior to that preliminary examination, there'll be a probable cause conference. That's where your attorney and the prosecutor will get together to see if there's a way to resolve the case short of going to trial. You do have the right to have a bond set, and your bond is based upon the probability of you appearing at future court appointments and the threat that you pose to the community. I see in the defendant's past, it looks like back in 18, there were 2 cases under HIDA, and the praxis scores him at a risk level 1. Any comment, Mr. Talinda? Sorry, regarding bond?
At the bond, Your Honor, I wasn't aware of a HIDA status. I guess my stating he has no convictions is still true, Your Honor. This is a marijuana case. I've been in touch with Mr. Kelly since I think within 6 hours of his arrest on this matter. I've been retained since the outset. I have been working with the detective in charge, Detective Wayner, up in Grayling.
Carefully
I believe
pronounce
his
that
partner
one.
is the one that did the swear to. Him and I have been in touch. We've been talking every week to get this matter to the arraignment stage. So we have, I believe, a resolution in hand. Mr. Kelly is not a flight risk. He's gainfully employed in the area. His family's in the area. He owns a house in the county.
We're just waiting for Judge Boyd to come back after lunch.
He's not a danger. Again, I've been retained since day one. So his appearance is not in question. I believe nor is mine, Your Honor. He has no other history of failures to appear. He does have family in the area still. And so with that, Your Honor, I'd ask the court to set a personal bond. As again, I've also been, I've been in communication with Ms. Carey at the outset, indicating the cooperation that we've had with the state police in this matter, and the good working relationship. So with that, I don't think there's any risk for safety of the community or a flight risk. I ask the court to set a personal bond.
That was a long request.
All right, given the cooperation that has occurred, the fact that it looks like the defendant turned himself in, I do not consider him as a flight risk. Certainly the amount of product that he had in plants alleged to have had are concerning to the court, but I will do a personal recognizance bond with the conditions that you appear as ordered, keep your contact information current, not leave the state without permission, and to commit no new crimes, no illegal controlled substances, including recreational marijuana, and you'll be subject to random testing for that as well. Mr. Kelly, at some point you're going to be released from the jail today. You'll have your next court date upon release, so make sure you keep track of that. And then you'll need to come over to Community Corrections, which is about 5 or 6 blocks from where you're at. It's on the ground floor of the courthouse, and get signed up for your testing requirements. Okay?
Yes, sir.
Anything else for the record, Mr. Talinda?
No, that's all, Your Honor. Thank you.
Ms. Lawrence? All right, thank you. We are adjourned on that matter, and that completes the docket for the day, so we are adjourned.
They're adjourned.
Thank you.
No.
Jump back in with Judge Dad.
Why you're confusing me to death here? You just said they were out last Friday. When are they scheduled to come out again?
I don't know. I have not received notice again. But they've been out 5 times.
Well, okay, let's get them out there 7 and 8 and 20 if we need to. I don't know what's going on. I don't know how bad it is, but
Judge, I'll check with the property. I don't know if they're still running into, there's some very strict and specific preparation protocols that the pest control contractors give to residents.
And everything was done. Everything was done.
Ma'am, just let me finish.
Okay, I'm sorry.
Let's try to cooperate with them. I'm giving you a court date for next Tuesday, May the 26th at 10:30. You have to be in person, okay?
Okay, that's fine.
You have to be in person, all right?
Okay.
I wish you well. Let them into spray, and it's not going to be your fault if you do that. It's going to be somebody else's fault. Thank you.
Okay, I'll be there next Tuesday.
Oh, here's your supplement that was just handed to me. Wow. Hang on.
Okay, I'm hanging.
You're not going to try to self-treat these bed bugs, are you?
No.
You're going to let them
assumed I was.
Well, you should never assume anything, but you're going to wait. You're going to let them in and spray, right? And take care of this?
They assumed that I was self-treating. I was not.
I didn't ask you that. I asked you, are you going to let them in to do their work?
Oh, yes, always.
Well, okay. You're going to be back in front of Judge Hessen next week. So I hope that there's some action taken on this, okay?
Well, they've been coming regularly every 2 weeks.
We'll see you here next Tuesday at 10:30, May 26th.
We'll see you then, sir.
Thank you.
I'm done.
Thank you, Judge.
Meadowlands versus Natasha Davis and Jalen Hill. Thanks, Mr. Butcher. 260-2057.
Mitch Joseph, Your Honor, P77016 plaintiff.
Good morning, or good afternoon. Do I have Natasha Davis? Yes, I do. Your name, ma'am?
Yes, Natasha Davis is here.
Nice smile. Nice to see people smiling here. Where's Jalen Hill?
Get Boyd up just
He's here. Hold on 1 second. He went to the restroom.
Let's just run the phone into him real quick.
Jalen, come on down, dear.
I'm in the bathroom.
All right, I'm sorry about that.
You're fine. You're fine.
Okay, we're going back to Boyd.
Mr. Hill, can you come up here and tell me your name, please?
Jalen, hurry up, baby. He's calling you. Hurry up and say your name. Sit down. Say Jalen Hill.
Sit down. Say Jalen Hill.
Jalen Hill. Sounds like, is that your boyfriend, girlfriend? What is she?
Oh, that's my son.
Oh, your son. I was going to say, you sound like you're under control there for sure. Mr. Hill, I'm going to need you to keep your voice up nice and loud. Did the two of you, Ms. Davis, and your son, did you, each of you, listen to the rights on the video?
Okay, we're going to bail on that. Yeah. We've had the fun part.
Did you, young man?
Yes.
And do either one of you or both of you wish to speak to a lawyer or apply for funding?
We'll never know. We'll never know. Here we go. All right. Back in Judge Boyd's courtroom, please move the water bottle. That's all I ask. Just grab it, move it. Oh, he's doing it on purpose. Look. He's checking to see where it is. He's going to slide it a little bit. Yep, you knew it. I knew it. Oh. I have words for this guy. It's not nice. That whole slanted look at the camera, slide the water bottle a little closer. What do we do? What do we do? I think the judge could order him to not do that because it will push the camera. But it's a smart man. Oh, he knows there's a camera right there. They can see it. He's looking at it right now. He's trying to hide behind the water bottle. Pulls his phone out, then a couple texts. If he gets thirsty, you can't drink from it because then we'll see him. Everyone's like, this is all I need to know about the defendant. Guilty. Okay, we're going to fast forward a little bit because we can. She was live for just a minute, so give me a second here. Oh, wait, look, he moves it. In an absent-minded moment. See if someone tells him to move it or not. He's got that on. Someone told him to move it. Someone told him to move it. Okay, let's skip forward. He's looking at us. Waiting for the jury to come in. Or the judge or something. We're live. We're live. All right, here we go.
Mr. Castillo, on your screen, you'll see a picture of that was previously admitted under State's Exhibit number 46. Do you recognize that photograph?
Yes, sir.
Okay, what is that?
It's a picture of the Tesla.
Okay. Is that a fair and accurate depiction of what you saw when you exited your vehicle that night?
It's pretty fair. It was more cloudy at that time just because of all the airbag residue, but it's pretty accurate.
Okay. All right. Can you see the other side of the vehicle from that viewpoint?
No, sir.
Now, as you sit here today, you know that Mr. Moody was on the ground next to the Tesla on the passenger side of that car, correct?
Yes, sir.
Okay. But on the day of the accident, at the time that it happened, did you know that Mr. Moody was there?
No, sir. I had no idea.
What was the lighting like that night? In that right here?
I mean, pretty dim. It was pretty dark that night.
Let's see the next picture.
Mm-hmm.
So this picture that we see here, can you describe what that's showing?
Please, for us.
Yes, it's a picture of the Tesla into the wall.
Get back up a couple seconds.
And into the wall.
Okay.
With the airbags deployed and the driver door open.
Is it further back than the last picture that we saw?
Yes, sir.
Can you see up the block?
Yes, sir.
On the sidewalk?
Yes, sir.
Okay. Now, the lighting on that picture, is that the way it looked? Or is that a lot brighter or a lot darker?
Overruled.
It was much dimmer than what the picture shows.
Okay. Earlier, you had testified that Mr. Lerma was walking up that sidewalk. Is that correct?
Yes, sir. That's correct.
If you can you point on that picture where you saw Mr. Lerma after you got out of the Tesla? You need to do it on the big picture so the jury can see it.
He was, it wouldn't even be in the picture. He was a little further down than what the picture shows.
So he was past this building that we see in this picture?
Pretty much past.
Okay. When you got out of the Tesla motor vehicle, what did you do? What was the first thing you did?
First thing I tried to do was just try to regain my composure, regain my ground. My legs were hurt. My arms hurt. My chest. It was hard for me to stand. I remember specifically falling on the floor at first, and then getting back up. Just scared. I mean, it all seemed like it happened so slow, but at the time, I would imagine it was pretty quick. Trying to regain my composure so I can try to see if Lerma was still around. And this is immediately after I opened the door. And so I stand up and I'm finally able to hold my own ground. I look within the vicinity of where the car is at and the door. And I just don't see Lerma anywhere until I peek my head over around the corner and I see him down the street. That's when I go chasing him.
Okay. Did you look around the accident site to see if anybody had been hurt?
I mean, the only person who could have been hurt at the time was me or Lerma, and Lerma wasn't in the car. Lerma was down the street. So just within this area is the only place I looked because that's all I thought at the time.
So why didn't you stay with the vehicle?
I was being shot at. I was being shot at. I was in fear for my life. I was in fear for Lerma's life, and I just wanted to get out of there.
Okay. Did you leave the scene that day?
Yes.
From your viewpoint of events that day, was it apparent to you that Mr. Moody required aid?
No, sir.
Did you even know that Mr. Moody was there?
No, sir.
Did you think, let me retract that. What did you believe was immediately necessary about leaving that scene?
If I'm being honest, I just felt like running was something anybody would have done under those circumstances of being shot at. So I just ran. That's the first thing I thought of.
I just thought, what would everyone else
ran.
do?
I didn't take the time to.
And I did that.
I mean, it's hard to process everything that happened that night at one time so quick in a matter of seconds. I just ran in fear for my life.
Earlier, you testified that you'd watched the Tesla video. Did you see that FJ come back around after you left?
Yes, sir.
Does that corroborate your belief that leaving that scene was immediately necessary?
Objection.
Sustained.
What would have happened if you'd stayed there?
Objection to speculation.
Sustained.
Tell the jury how you were feeling when you left the scene that night.
I feel like if I would have stayed at the scene, I would have been shot, would have been hunted down, I would have been killed. So I ran in fear for my life.
Had you done anything to cause the FJ driver to start shooting at you?
No, sir.
Where'd you go after the crash?
I remember chasing Lerma down, trying to talk to him about, the situation that just happened. And I remember the whole time trying to talk to him, trying to, offer some type of assistance. He's just shrugging me off. He's giving me a hard shoulder with his right hand while he's on the phone, telling me I'm good. I'm good. I'm going this way. I have a ride coming. I told him, I said, well, if you want, I'm going this way. And he wouldn't look at me. He wouldn't talk to me. At one point during this whole altercation, while he's talking on the phone, he's just getting more visibly upset.
Careful on the hearsay.
More vocally upset. I just decided to go my own way, and he goes the other way.
Did you have your phone with you?
No,
at that
sir.
time?
I had my phone. Knew my phone was in the car. Yeah, so that's where it was at.
He knew it was in the car?
Did you ask Mr. Lerner to call 911?
Part of the altercation was me trying to take the phone. Because at one point I'm trying to communicate to him that I need to make a call. We should make a call. And he's not even making eye contact at that point. He was more worried about himself. It would appear that he was more worried about himself at the time and didn't really care to offer any type of assistance or help.
Does the Tesla motor vehicle have the ability to call 911 in the event of emergency?
My phone and my Tesla both have the ability upon impact to make an emergency call.
Okay. Do you know if they did that night?
Based off of what I saw in the pictures that were presented,
I'm gonna back up second for lack of personal.
Sustained.
Pull up the picture.
I'm not comfortable with how many times this defendant is trying to insert the key legal terminology of being afraid for his life and afraid for someone else's life in his answers. It doesn't sound natural, especially in his it doesn't fit in the vernacular that we've heard from him as he's told other stories.
No, stop one. Right, with this one? No.
Did I say victim? I said defendant, right? Yeah, the buzzword bingo. Say the right thing to make the law in your favor, but
I'm going to show you a picture that was previously admitted under State's Exhibit number 46. Do you recognize that?
Yes, sir.
What is that?
It's a phone that appears to be mine with some notifications on there.
Okay. You see a notification for Tesla on there?
Yes, sir.
How many notifications does that provide?
7.
7 notifications. Is that the Tesla calling 911?
Yes, sir.
Okay.
And I do know that my phone called because my mom actually got an emergency text message. Who was on my emergency contacts for in the event of a collision or something that happens with the vehicle wreck along those lines. She would get a text message.
Okay. And we've seen the picture of that phone, correct?
With the medical ID and stuff, yes, sir.
Okay. Okay. So after you confront Mr. Lerma, he pushes you away. Where does Mr. Lerma go?
He makes a right. He makes a right. I don't know the name of the street, but he makes a right onto the street. And after he decided to go which way he did, I just continued to go to Ashley's house.
Okay. At this point, are you walking?
No, I'm running.
Okay.
I'm running.
Okay. How long did it take you to get to Ashley's house?
Probably less than maybe 5 minutes. I remember going through back roads of the King William district where it's really, really dark, older Victorian houses, and just running and finally getting to her apartment.
Okay. So what happens when you get to Ashley's apartment?
And I just remember being super scared. I remember there was a stairwell in the back. I'm really still just trying to process everything at that time. And, you know, I remember hiding underneath the stairwell for a little bit, trying to compose my thoughts and get myself situated. I remember going upstairs and knocking on the door and trying to get her to come to the door to come inside.
Did you have your shoes on at the time?
No, sir.
What happened to your shoes?
One came off when I was running, and the other one stayed behind.
So, does Ashley answer the door?
Eventually, yeah, she answers the door.
About what time is it at this point?
1 in the morning, I believe.
So how far had he walked barefoot or ran barefoot?
I would say so, around 1. I forgot the exact time. I don't recall the time.
Okay. Somewhere between 1 and 2?
Yes, sir.
Okay. All right. So you get to Ashley's house and she opens the door and what does she say?
She's pissed off. She's looking at me, telling me that I look like shit, and what do I want?
Is that what she said exactly?
Calls for hearsay.
Sustained.
Okay. So she's upset with you?
Yes, sir.
Okay. And is she trying to help you?
No, not immediately. No, sir.
What did you want Ashley to do to help you?
To let me inside the apartment. I was scared. I just wanted to go inside and get some time to figure everything out.
Okay. What were you going to do with the car? You just going to leave it there?
Well, it wouldn't stay on, so I was just going to take the keys, move it where it needed to go inside.
So I that was a bad question. That was my fault. Talking about the Tesla. So the Tesla at this point is still over at the intersection of Alamo and Probable, correct?
Yes, sir.
Crashed into the wall.
Yes, sir.
What were you going to do with the Tesla?
So initially, I mean, at that point, I thought maybe I would just deal with it in the morning. I figured I'll get a ticket for damaging a building, get a ticket for something along those lines. And my whole mindset was just dealing with the consequences as soon as I'm out of immediate harm's way and being shot.
Okay.
So I'm not worried about that stuff.
So did Ashley ever help you with anything, or what'd she do?
You know, after talking to her and her not letting me inside, the only thing she does is just say, you know what, I'm just gonna get you a lift, get you to your apartment, get you out of here. So he orders a lift and doesn't let me wait inside. She tells me to go wait in front, that's where it's gonna be. And so I just remember pacing to the front, pacing back to the back underneath the stairwell, and just waiting for the car to show up.
Okay. Did you ask to use Ashley's phone to call 911?
No, sir.
Why wouldn't you do that?
Because I knew that my car or my phone would take care of it.
When you say take care of it, what are you talking about? What do you mean?
The emergency features on the vehicle, emergency features on my phone. When it detects a car wreck or it detects a large fall, it alerts authorities and your emergency contacts.
Okay.
You were okay with the police just knowing that there had been a crash and have no idea where the people in the car were? Just whatever. phone. The car will take care of this.
So what happened the next day?
I was in severe pain. I remember laying down most part of the day. And looking at trying to figure out what my next steps were.
Okay. Did you find out what had happened that night?
That was part of it.
What did you find out?
After trying to look up how to find where my car might have been, it was on one of the reports that there was a hit and run on Alamo Street with a car.
Okay. So after you found out that you'd hit someone in that accident, what did you do?
Just I mean, a lot. I broke down in tears. That's what I remember. I remember my mom getting a hold of me, and I remember talking to my mom about the situation. She brought my kids to me, and I was just grieving. I was trying to get things situated. I was crying. I up until the next few hours, just trying to process everything, because for me, I thought it was just a simple trying to save me and my friend's life. And I found out that in that situation that somebody died, and it was very hard for me to, up until this day, to really deal with it. And so I just remember crying in my kids' arms, because I knew I had to turn myself in. I've never been in a situation like this in my entire life, so I don't know what's going to happen next. I don't know if this is going to be the last time that I get to hug them, the last time I get to see them. Same thing for my mom. And so my brother. And so for me, I just take a few days to
Brendan.
Embrace them and be with them, try to have all my affairs set up for them, my bank accounts, things of that nature. And had my uncle and my tia come and talk to me, pray over the situation, prayed for Eric Moody. They prayed for me and my kids and my family.
This is consciousness of guilt.
The same thing for my mom. So then after that, make the decision to just go turn myself in.
When did you turn yourself in?
I don't know the date. I think it was the 25th. 24th, maybe. I don't recall the date.
It's okay. I mean, how many days after? Hold on, Brendan. You got all kinds of things going on.
Who's Brandon?
And I'm done with that picture. If you want to just take it.
Oh, Brandon's doing things on the screen while he's up testifying.
Get off screen share.
You good? Thanks. I just didn't want you to put something up there you didn't want to see. And so I guess I'm asking, did you, the day after this accident, did you turn yourself in that day, or was it the next day, or do you remember?
It was the day after the accident. The day after the accident.
Okay. Okay. So
after he'd sobered up, possibly.
When you turned yourself in, what happened?
I remember walking in. I was surrounded by my mom, Ashley, my uncle, and yeah, came by, and you know, just did a little crying, did a little more prayer for the whole situation, and I remember going in and just walking into the station and talking to the person at the front desk.
Did they arrest you right away?
No, sir, not right away. She asked me what I was there for, and I remember specifically telling her that my vehicle might have been involved in the situation.
Might have?
At what point did you go to jail?
Immediately right after that, I got arrested.
Okay. All right. When you found out that Mr. Moody had been killed, how did that make you feel?
Terrible.
How does it affect you now?
Action relevant.
Sustained.
As you were fleeing and being shot at, did you mean to drive on the sidewalk when Mr. Moody got hit?
No, sir.
That wasn't intentional?
No, sir.
Did you mean to drive the Tesla off the roadway?
Sir.
Did you drive the Tesla that night under the influence of alcohol?
Yes, sir.
Did you drive the Tesla that night under the influence of a drug or a dangerous drug?
No, sir.
Would you have been driving the speed you were driving if you had not been actively shot at?
No.
Would you have had to duck down behind the dashboard if you were not being actively shot at?
Sustained.
If you had not been being actively shot at, how would you have been driving your car?
I would have been driving perfectly normal.
You wouldn't have run the first red light, which was before you got shot at?
In all likelihood, would Mr. Moody be alive today if you had not had to take evasive action to avoid being shot at by the driver of the FJ?
Objection.
Sustained.
Who do you think caused all this to happen?
Objection. Yes. Calling for a legal conclusion and waiting for the jury.
Sustained.
That's the witness, Judge.
State your witness.
All right, Mr. Castillo. So it is your testimony that this celebration that we put together was sanctioned by Take Private Oil. Is that correct?
What was the definition of sanction?
It was, I guess, under the umbrella of Take Private. So it was authorized and approved by Take Private Oil. Is that correct?
It was authorized by the direct supervisor of the managers, which would have been me.
Okay. So it was authorized by you, but not your boss. Is that correct?
It was brought up and it wasn't opposed by them.
Okay. And so, in you putting this celebration together, you all decide to go to El Camino. Is that correct?
They decided, yes, ma'am.
Okay. And when you say they, you're referring to Antonio Lerma and employees at his store. Is that correct?
Yes, ma'am.
Okay. And so, I guess, how did Jared end up in this celebration for Antonio Lerma's store if Jared Lopez worked at a different store?
So long story short, Jared was a district manager in Corpus Christi. He had some family issues. He had to come back down to San Antonio, and that came with the demotion. And so Jared was also a training store. And so training store manager is typically the next person up. And so Jared was invited to go, and that was a unanimous decision by the shop that Lerma was at, and I okayed it.
Okay. So the celebration for Antonio Lerma's store also included Jared Lopez, is that correct?
Yes.
All right. And so it's your testimony that under this authorized celebration that's authorized by Take 5 Oil, Antonio Lerma and Jared Lopez meet up with you at your apartment complex, correct?
Well, it wasn't authorized necessarily by Take 5. It was something that I had decided to do, and it wasn't denied by my higher up. It was something that we always weekly or every other week reward a team, whether it be bowling, taking them out to eat. So
they go out, take their team out to drink every week.
Authorized by, that was just the standard, and that was just the culture of Take 5.
Okay.
It's the 5 we're taking.
So my question to you was,
oh man,
in this celebration, that was, because what you have reported to this jury is that it was a work celebration. Jared Lopez and Antonio Lerma met up with you at your apartment, correct?
That is correct.
Okay, and then the rest of the employees, y'all met at El Camino, correct?
They decided they wanted to do this at El Camino instead of the apartment. Yes.
Okay. And so I guess my question to you is, was it normal for Take 5 employees to do work authorized get-togethers at people's apartment complexes?
What do you mean by that?
If this celebration was authorized by the corporation Take 5, was it normal for Take 5 to authorize work celebrations to occur at employees' apartment complexes? Was that the standard of brand care that was going on at Take 5 at that time?
Well, we didn't celebrate it.
So what were you doing at the apartment?
That's where we meet up, and we went to go celebrate at El Camino. We didn't celebrate at my apartment.
Okay, so that first beer that you consumed while you were in your apartment, what would you call that? Not celebration?
Not a celebration.
So what would you call it?
Well, it was one beer. I mean, in between just me and Jared at that time, Lerma had not arrived, and it was just a beer that was in the fridge, so I just drank it.
Okay, because at that time y'all are just kicking back and hanging out, correct?
Not necessarily, no.
Okay, so what were you doing while you were consuming that alcohol beverage?
We were waiting for Lerma to get to the apartment so we can leave.
Okay, and is it normal in Take 5 authorized celebrations for Take 5 to authorize employees to spend the night with other employees?
I don't know the answer to that.
Okay. So you're not aware if Take 5 had some type of anti-frat policy?
It wasn't a frat.
I mean like anti-fraternization, like spending the night with other coworkers and engaging in behavior.
The only thing that I was aware of was higher ups can't be dating people that directly report to them in terms of, I guess, the question that you just asked me. I'm not really sure what you mean by fraternize or.
Well, fraternize.
Hanging out outside of work is what I mean.
Oh, yeah, I mean, they don't tell you who you can and cannot hang out with outside of work. That was never an issue.
So they were okay with you all spending the night with each other. That was authorized by Take 5?
Who was all like just
You
learn?
and Antonio Lerma.
Well, at that point, it wasn't a work event anymore. It was just me and Antonio Lerma at the apartment. And if he wanted to spend the night, he was also my friend. So I didn't have an issue with him spending the night at my apartment.
Okay. So I guess I'm having trouble. Can you just explain to the jury what time did the take 5 authorized hangout start and end? Because I'm having trouble understanding that.
Objection sidebar.
Sustained.
What time did the take 5 authorized
Objections sidebar.
hangout start and begin?
It was at my discretion. So it started when everybody met up at El Camino where the original plans were.
And when did it end?
As soon as everybody dispersed from El Camino.
Okay. So the hanging out in your apartment with Jared and Antonio Lerma, who you know are your friends, that was not authorized by Take 5 Oil, correct?
I mean, no, at that point it wasn't a work event.
Okay. So that behavior that you were engaged in was hanging out with friends, correct?
Not necessarily, no.
So then what was it?
She's
What
frustrated.
do you mean by what was it? Like,
If you weren't hanging out with friends, when you were at the apartment complex, prior to El Camino and after El Camino, what would you call and what would you represent to this jury going swimming and drinking beer is, if it's not a work authorized event? What is it?
Well, I wasn't drinking beer at that time. I had drinking beer around 7:30. So at that time, maybe afterwards, when we arrived to the apartment where there was no beer involved, I guess some can consider that hanging out, but that's all it was. And I was still at some point responsible for the safety of Jared and Antonio. Just it was just a moral thing for me to do. Like Jared came, side of town that came from me just to make sure it gets to his ride. And same thing with Lerma.
Okay, and so now you're saying that you had a responsibility, even though this hanging out at the pool was not a work-related event, correct?
Well, I said it was just a moral obligation within myself.
Okay, but earlier what you said is that you were responsible for them under the guise of the company, right?
Up until we left El Camino.
Okay, now up until you left El Camino.
Well, there's a difference between being responsible for them at El Camino and the moral compass when we arrived to my apartment.
Okay. And you just stated right now that there was no beer at the pool, but that's not what other witnesses testified to, right? You heard that?
I don't remember. It's been a very emotional week for me, so I don't recall.
That's not the question that I'm asking you.
Okay.
Did you hear the other witnesses testify that there was beer when y'all went back to the pool after El Camino?
Objection asked and answered.
Overruled.
You can answer the question.
I don't recall.
All right. Now, you testified that Antonio Lerma had been drinking that night and that you recall him feeling good or being buzzed. Is that what you stated to your attorney?
Yeah, I believe it was along the lines I would assume. I think that he might have been buzzed, but I can't determine that.
Okay, and have you heard that he said the same thing about you?
From his testimony, yeah, but then he later retracted it, saying that I wasn't. So I'm not really sure.
Okay, and have you heard of what he told the detective, that you were intoxicated and buzzed and feeling good? Have you heard that?
Which statement?
That he made to the detective in the course of the investigation.
Judge, I'm going to object. That is not in evidence, and that is hearsay.
All right, that will be sustained.
Move to strike and disregard.
All right, ladies and gentlemen, you're to disregard the last answer.
All right. So then it's your testimony that when y'all leave El Camino, before arriving back at your apartment, you, Jared Lopez, and Antonio Lerma pop into Elsewhere Garden. Is that correct?
Yes, that is correct.
Okay, and that is a bar located in downtown San Antonio that sells alcoholic beverages, correct?
Yes, ma'am.
All right. And you stated that y'all stayed there and then from there moved to your apartment complex on Newell Avenue, correct?
Yes, ma'am, that's correct.
All right. And then after that, Jared leaves from your apartment, correct?
We walked into the right, so yes, ma'am.
Okay. So from your apartment, you walked him to the right where?
It was under the bridge where he had arranged for the drive to meet him. So we walked out the apartment, walked like 2 or 3 blocks down the street, kind of by where the pig stand was at, but a little closer in towards the apartment. And then we walked back.
All right. And then when you all arrived back, you testified that that's when Antonio takes a shower. Is that right?
Yes, ma'am.
Okay. And then during this time, you are calling Ashley Sanchez, correct?
I don't remember.
All right. And you testified that you and Ashley Sanchez were not in a relationship with each other at the time of the crash, correct?
That is correct.
Okay. And your relationship with Ashley Sanchez would, I guess, be characterized as tumultuous. Is that fair to say?
Objection relevance.
Overruled.
What was the question?
Your relationship with Ashley Sanchez, I guess, how would you characterize it? It was kind of on again, off again, right?
No.
No?
No, ma'am.
Well, how would you describe your relationship with her?
Complicated, I guess.
Okay, because you guys would be together sometimes, correct?
No, she had lived with her boyfriend at that time.
I'm talking about from the time that you started creating children with her
Oh, okay.
to the time of the crash.
That's rather specific.
You all would be on again, off again, correct? You'd be together sometimes and then break up and get back together, correct?
Judge, I'm going to object. That's a multiple question. If she can narrow that down to one question, have them answer.
All right, that'll be overruled.
You can answer the question.
It was up like a year before the wreck happened. We were in there was no going back and forth. We were in a relationship.
Okay. And in your relationship with her, well, we'll get started. So then it's your testimony that before you left your apartment complex to go to Ashley Sanchez's residence, that you inspected the back of the Tesla and did not see any defects in the back. Is that correct?
Correct.
Correct? Correct. Whoa. Do you see how they jumped on that? I think they have video. I think they have video of the Tesla. Boom. They just got caught in the lie.
Just regarding you, you're able to walk just fine, correct?
And what do you mean?
Like you don't have any limps or gaits or anything like that, right?
Just in my right leg. And it depends what kind of shoes I'm typically wearing too.
But you were able to walk up to the stand just fine today, correct?
Yes, with a little bit of pain. I had just recently sprained my ankle extremely bad. I have a police report for it as well.
For when did that occur?
Maybe like 3 weeks ago. I was going for a job on Broadway Street.
I'm stopping there. Okay. So 3 weeks. Listen to the question now.
Good for you.
You sprained your ankle 3 weeks ago, correct?
Yes, ma'am.
Okay.
So he says she said it's your testimony that before you left that night to drive from the apartment, you checked the back of the car.
Take a look at the screen on the right.
For bullet holes. The car films all around it, so it would have seen him checking for bullet holes. So he's going to have to clarify or acknowledge that he didn't.
All right, so tell this jury when you look at the back of the Tesla to make an inspection as to whether there's defects.
I mean, right there, right when I looked at it, I at the back.
Okay, when? Tell me when.
They're going to change angles and they'll have him looking somewhere else. You can't.
Right there. Looks like it. And right there.
When your head's down and you're looking at your phone, you're telling the jury that you looked at the back of that clock.
And can you rewind it?
Let's be clear, you have your phone in your hand, correct? When you walk up to that Tesla?
You can just rewind this. I can take a look one more time. Not all the way back, just.
I think they caught him in a lie.
All right, so we see that you have your cell phone in your hand, correct? You're looking down at your cell phone.
Right there, I'm looking for.
You're looking at the charger, correct?
The phone's in my pocket at that
You
point.
just placed it in your pocket, correct? And then you turn around and get in the motor's vehicle, driver's seat, right?
Yes, ma'am.
Okay, and you have an unnatural gait and stumbling to the driver's seat, correct?
I mean, with poor choice of pants and shoes, I didn't have a belt on, but I would say so, yes, ma'am.
You have an unnatural gait stumbling towards
I'm
the
gonna ask you to
drivers.
step off of the stand and walk in front of the jury.
Objection?
I have to. Do I do that?
Yeah. Yep.
Where at?
Straight across. Okay, start walking.
Start walking.
Okay, you're perfectly fine, right? You're not losing your balance, right?
I'm in pain now.
Okay, from an incident that happened 3 weeks prior, correct?
Yes, ma'am.
All right, you can turn around and take the stand again.
Unnatural gait and stumbles.
Now, you testified that you had prior knowledge that your Tesla was able to accelerate quickly, correct?
Based off of research, like I had said, yes, ma'am.
Okay, so you're saying that you had no personal knowledge as to what speed the Tesla could operate at?
I mean, I've never really like personally tested it, and if that's what you mean, like see how fast it goes.
So basically what you told this jury is something that you yourself looked up on the internet, correct?
So.
Okay. And then regarding the Tesla, you've seen the videos that have been introduced into evidence, right?
Yes, ma'am.
And you saw that you committed multiple traffic violations while operating that motor vehicle, right?
I believe it was 2, yes, ma'am.
2?
I believe so.
Okay, well, let's start with 1. So starting off, when you enter into that driver's seat, you don't put your seatbelt on, correct?
Correct.
Okay, and you operate that motor vehicle from Newell Avenue all the way to South Alamo and Provan, not wearing a seatbelt, correct?
That would be correct.
Okay, so that's traffic violation number 1, correct? Okay, then you saw in the state exhibit that you stopped in passenger crossing multiple times, correct?
Objection. I don't even understand what that question is. What's a passenger crossing?
All right, that objection will be overruled.
That's your cue.
I'll return the question.
Yes, ma'am.
You observed yourself stop in pedestrian crosswalks multiple times on the state's exhibit, correct?
I believe it was once at the Pullman market, but I don't recall.
Judge, if I could just have a minute to get something going. Well, I guess I'll move on because the jury has seen the exhibit. So then after stopping in the crosswalks, Then you get to the intersection where you're gonna move from the access road onto the highway, correct?
Yes, ma'am.
Okay, and you commit a multi-lane violation, right?
Yes, ma'am.
Okay, because you were in a lane that was supposed to go straight only, correct?
I don't know if that was a straight only lane. It's a possibility.
All right.
They're picking out all of his traffic offenses that are captured on the video of his car.
Okay, so you see the lane of traffic that you are traveling in, correct?
Yes, ma'am.
And so it's a straight and right turn only, correct?
Yes, ma'am.
So there's no way for you to get on the highway from that lane that you're traveling in, correct?
I mean, if I'm being honest, it's a little bit confusing, but if that's what, I mean, I
That's
don't.
not what I'm asking you.
Okay.
There is no legal way without committing a traffic infraction for you to go from this lane and get on the highway. Isn't that true?
Yes, ma'am.
All right. Wait.
This is driving normally. It's going to end with him running a red light. It's a good move by the prosecution here.
And then if we're looking at the lane that you are in currently, it's a right turn only onto McCullough, correct?
Yes, ma'am.
Okay. And the lane that you're in currently is to continue going straight on the access road, correct?
Can you rewind it? A little more.
A little more.
Right there. I'm trying to see the signs.
Okay, well look at the floor. Look at the floor. Because the two signs that are displayed are regarding the two left turn lanes, correct?
Yes, ma'am.
Okay, because the lane that you get into is to continue on the access road, right?
Yes, ma'am.
All right.
Now I don't want a Tesla anymore.
And then we can see you passing multiple cars, correct? Traveling at a high speed speed, right?
I don't know how fast I'm going in those videos.
It's faster than other cars, you would agree with me, right?
It would appear to be.
And then you end up at the intersection, or to make that, you take the exit to make that left turn on South Alamo, correct?
Yes, ma'am.
Okay. Are you confused? I guess I'll rephrase my question. So from the video that we just saw, right, you exit off of the highway, correct?
I said yes, ma'am.
Okay, and then you end up at that red light on South Alamo to turn left to go to Ashley's house, correct?
Yes, ma'am.
And then that's when you first observed the Toyota FJ, right?
That is correct.
Okay. And so while you were at that red light, that's when the Toyota FJ runs the red light, correct?
Yes, ma'am.
Okay, and then you follow up and also commit another traffic violation and run the red light, correct?
That is correct.
Okay.
So that's driving normally.
And then, so it's your testimony that the Toyota FJ got off into the lane beside you, correct?
To the right of me, yes, ma'am.
To the right of you by the passenger side of your vehicle, correct?
Yes, ma'am.
Okay. And then at this time, you stated that you rolled your window down because you wanted to lend, okay. that the Toyota FJ driver rolled his window down first. That's your testimony, right?
It was that Lerma put the window down, not that I rolled the window down.
So at the time that Lerma rolled the window down, was that Toyota FJ window already rolled down or no?
Yes.
Okay. And so Lerma rolls the window down. And then, so I guess, how would Antonio Lerma know to roll the window down? Because it was your testimony earlier that you wanted to make contact with the Toyota FJ to lend a helping hand.
Judge, that calls for speculation. She's asking how Mr. Lerman knew something.
I'm sorry, could you repeat your question, please?
Yes. So it was your testimony earlier that you slowed down and engaged with the Toyota FJ because you wanted to lend a helping hand to him. Isn't that right?
Yes, ma'am.
Because you said you've done that many times before, correct?
That is correct.
Okay. And so now you're saying that you're not the one that rolled down the window, it was Antonio Lerma, right?
That wasn't my testimony earlier, yes, ma'am.
So how did Antonio Lerma know to roll the window down so that you could offer a helping hand?
Objection calls for speculation.
All right, that'll be overruled.
You can answer the question.
What?
I mean, I would, for lack of a better word, just assume that's common sense. The way he pulled off to the side abruptly and slowed down in the brakes. I don't know what's going on through his mind. I couldn't answer that for you.
But you're asking this jury to believe that Antonio Lerma is the one that rolled the window down.
Well, it wasn't me.
Okay. But you heard Antonio Lerma's testimony, correct?
Yes, from me.
Okay. And he said that you're the one that engaged with that motor vehicle. You recall that?
Did he state who put the window down?
He stated that you're the one that engaged with the other vehicle.
Well, it's simply not true. He had the window down first and then put it down.
Judge, can you purchase it first, please?
Yes.
I don't think they asked the passenger who rolled the window down. I don't recall. It wasn't me. Sorry, Lena. It wasn't me. But this seems bizarre that the question literally is asking for, how did someone else know this? Now the witness is about to cry. He's like breaking down right here. Yeah, I think the judge messed up on that one. Again. Grandbaby number 6 should be here any time. Then we'll have to sing happy birthday and free pancakes. His lawyer's trying to help him, but he's not picking up on the clues.
Okay. And then you testified that on the night of the crash that you cannot recall where exactly your firearm was located. Isn't that correct?
Yes, I said that I don't recall, but out of a force of habit, I put it in the center.
But I'm asking you, you stated that you do not recall exactly where it was, correct?
Yes, ma'am. I was just.
You're relying on. Okay, I'm going to ask you to not speak over me. Let me ask my question.
Judge, I'm going to object to sidebar. And by the way, she was speaking over him. He's trying to answer.
All right, the objection will be overruled.
I'm going to ask my question and then you can answer, okay?
Yes, ma'am.
Okay, so what you stated when your attorney was questioning you is that you do not exactly recall where the firearm was located in the motor vehicle, correct?
That part of the statement is correct.
Okay, because you're just relying on what you did other times, right?
What do you mean by that?
When you say that as a force of habit, you would always put it in the center console, you're just reporting to the jury what you did times before, right?
I mean, essentially, yes, ma'am.
Okay, because you don't have any recollection of where it was at the time that you're engaging with Toyota FJ, correct?
wasn't on me, but yes, ma'am.
How do you know it wasn't on you if you previously stated that you didn't know where it was?
Based off of the pictures that were in the exhibit where it was retrieved at the time.
After the motor vehicle crash? Correct?
Correct.
Okay, because we know that a lot of things bounced around in the motor vehicle when you hit Mr. Moody, correct? Is that a yes or no?
Yes.
Yes, because just like that hat that you were wearing on your head, it didn't stay on your head, did it? No, it ended up somewhere else in the car, correct?
Correct.
Okay. So then what you're asking this jury to believe is that even though you didn't know where the firearm was, you're asking them to just rely on what you did prior to this road rage incident to believe that you didn't have that firearm on your lap when you were engaging with the Toyota FJ, correct?
That's correct.
So then you testified. Well, I guess how would you describe the Tesla motor vehicle? It's pretty low to the ground because it's a car. What did you say?
Yeah, I wouldn't know the specifics on that car. I think it was middle tier, so they tend to be. I don't know the specifics, if I'm being honest.
Okay. But it was your car, correct?
Yes, ma'am.
Okay, you've operated it many times prior to the crash, correct?
That is correct. Yes.
So, in your experience with it, it wouldn't be as high up as like a Ford F-150 or a truck or anything like that, right?
It was definitely different from the minivan that I had. Yes, ma'am.
Okay. And so then you testified that from the driver's seat of your white Tesla, that you're able to see the driver of the FJ pop his elbow on top of the driver's side window, correct?
Clear as day.
And then point a firearm at you under that, correct?
Yes, ma'am.
Even though that Toyota FJ is way higher up than your Tesla, correct?
I don't know if that's necessarily correct. I don't know how higher it was, but I do recall seeing the barrel of the gun pointing at me in that room.
Okay. All right, so if we look at Defendant Exhibit number 3, I'm gonna ask you to take a look at that. Okay, if we're able to see, this is a vantage point from the passenger side of the vehicle, correct?
Yes, correct.
Okay, and that would be a closer vantage point than you have at the driver's side of the motor vehicle, correct?
What do you mean by that?
That this side, the passenger side, has a better view of that motor vehicle, the Toyota FJ, than you would on the farther side on the driver's side, correct?
I mean, it's up to the person, I guess.
What I'm asking you is the passenger side of your vehicle is closer to the Toyota FJ than the driver's side of your vehicle. Isn't that correct?
That would be correct.
Okay. And so being that it's closer, the passenger would have a better vantage point than the driver, correct?
Objection calls for speculation.
Overruled.
What's the question again?
The passenger being closer to the Toyota FJ would have a better vantage point than the driver who's far away, correct?
Yes, but at this point, me and Lerma are both making eye contact with the driver because he's being pretty verbally aggressive with us. So
Okay, but you heard Antonio Lerma's testimony that he was at this moment telling you to just drive off, right?
he said yes, ma'am.
Okay. And so when we're looking at Defendant's Exhibit number 3, it would appear that this Toyota FJ is higher up in stature than your Tesla. Wouldn't you agree with me?
Yes, but that doesn't mean that I can't see the driver.
Okay, so what you're asking this jury to believe is that from a lower vantage point, you were able to see an elbow and then under the elbow, a firearm.
If there was absolutely anything I could have seen that day, it would have definitely been an elbow and a firearm, considering it's closer to the door. But I would say, yes, ma'am. It's I don't know how much taller it is. I don't like the vehicle's not that much lower than Tesla.
Okay. And so even though if there was anything that you would have seen that day, it would have been the firearm, you're unable to explain what that firearm looked to the jury, correct?
I saw a barrel and then I heard shots right after.
My question to you is, are you able to describe what the firearm was besides the barrel? Could you say if it was a 9mm or a 45 or a 38?
No, but
No,
I can tell
because
you
all
that
you
we
said
were being shot
that-
at.
Judge, she's badgering the witness. He's talking over the top of him. She needs to let him
I'm
answer the
object
question.
to speaking objections. If you could just make a legal.
Those are legal objections. She's badgering the witness. She's talking over the top of him, and she's not letting him finish his question. Those are legal objections.
All right. Thank you. All right, this is what we're going to do. Questions will be asked. Wait for the answer. Cindy can only take one person at a time.
Yes.
All right, thank you.
So my question to you is, when you were being questioned by Mr. McLean, you stated that you couldn't describe the firearm. You just saw the barrel under the elbow, correct?
Lean back and then a barrel at the elbow. That is correct. And then shortly after, when I stepped on the gas, I heard shooting.
Okay. So I'm going to reiterate my question again. Besides you seeing the barrel, you're unable to describe the make and model or caliber of the firearm, correct?
With the lighting conditions, I don't see how anybody would be able to do that, but that would be correct. And right after.
Okay. But with the lighting conditions, you saw the barrel.
I mean, that's correct.
Okay. So then you say that at this point, when you see the barrel of the gun that you can't describe, that you're in fear for your life, correct?
Correct.
And you're familiar with the Frio substation because that's where you turned yourself into, correct?
That's correct.
Okay. So you know that that's about a 4-minute drive from where you were on South Flores and Alamo, right?
I don't know the exact time, but if you're saying that's 4 minutes, then I'll take your word for it.
Okay. Okay, so if you don't know the exact time, but you know that it's very close to where this interaction with the Toyota FJ occurred, right?
That's correct.
Okay. And instead of you turning around and fleeing and going to the police substation, you decide to floor it.
I'm not going to argue about semantics.
Correct?
Yes, ma'am.
And then in the action of you flooring it, the Toyota FJ takes that right turn onto South Flores, correct?
It takes some shots and then makes a right turn.
Okay. You observed it shoot at you?
I heard it, and I heard it hit my window,
Okay.
and I heard the car get hit. Yes.
You heard,
A gunshot. Yes, ma'am.
but you did not see where it was coming from, correct?
I was stepping down for my life.
So listen to the question. If you were ducking down, you didn't see where it was coming from, correct?
No, but I heard it come as soon as I saw a barrel gun, so I would assume and probably know that it came from FJ.
So that's what I'm getting at, is that you're assuming, right? Because you didn't see.
I know it came from FJ.
How do you know if you didn't see?
I saw the gun. I heard the gun shots after.
Okay. And so then at that point, instead of driving to the substation that's less than 4 minutes away from there, you continue on and strike and kill Mr. Moody, correct? Yes or no?
I'm taking time to think about the answer.
That's a bad look.
I strike Mr. Moody, yes, but I did not know he was there.
So the question is, you struck and killed him, correct? Are you really gonna dispute that to this jury?
Objection, Judge. Let him answer the question, and she's badgering the witness.
All right, with regards to badgering,
Shit.
that will be overruled.
Is it in dispute in your mind that you struck Mr. Moody and caused his death?
I know he was struck, yes, ma'am. I know he died that night.
And who was driving the motor vehicle that struck him and caused his death? You.
I didn't cause it, but I was driving the vehicle.
How did you not cause it?
Because I didn't point a gun at Mr. Diego, he pointed a gun at me.
Just as the FJ driver is
And
responsible.
you had every opportunity to call 911 if that was true, correct?
Correct?
But you didn't do that, did you?
Not at that exact time of the incident. I was still trying to comprehend everything after the wreck and in fear for my life.
Okay, but let's be clear
Yes, ma'am.
to this jury. You never called 911 and reported what occurred. Isn't that true?
I made an attempt to use Mr. Rimmer's phone when he wouldn't let me, and also my phone. I know that it has an emergency feature along with my car to make that call for me.
Well, let's talk about that because Mr. Lerma has a different version of events, correct?
That is correct.
Because you heard him testify that he advised you to call 911 and you didn't want to.
I told him I didn't have my phone.
Okay, but let's talk about what wasn't said. You never said, give me your phone so I can call 911, correct?
That's not correct.
So it's your testimony to this jury that you told Antonio Lerma that you wanted to call 911.
My testimony that I tried to take his phone because I didn't have my phone to make a call.
So how would he know? And how is this jury to believe that that's what you wanted to do, call 911?
No one else I could have called.
Well, you could have called Ashley like you had been calling her earlier in the day, correct?
Yeah, but she was already down the street. It was like within a 5-minute radius, maybe less. I wouldn't have called her.
Okay, but let's get back to my question,
Okay.
which was you never obtained a phone, dialed 911 yourself, and reported what occurred, correct?
To this day.
Okay. It's a yes or no question. Did you? And the answer is no, right?
Didn't obtain a phone.
And you did not call 911, right?
Would be correct.
Okay. And then when we're talking about Mr. Lerma allegedly pointing this firearm at you,
Who?
I mean, Mr. Gomez, Diego Gomez, the driver of the FJ allegedly pointing this firearm at you. You had every opportunity to flee then, correct?
I mean, it was only a matter of seconds from when I saw it that I sped off. I wasn't staring at the end of the barrel for 5 or 4 seconds.
So my question to you is, did you have an opportunity to drive off at the time that you were engaging with Mr. Gomez?
Now, was that to your first question when we brandished the weapon or just in general?
In general.
Yes, ma'am.
Okay, because you could have driven off at any point, right?
Yeah, I think about it every day.
Okay, and that would have been the appropriate time to flee, right? Not after you killed Mr. Moody, right?
There wasn't an imminent threat at the time.
There wasn't one when you crashed into Mr. Moody, correct? Because in the testimony that you've given, you don't describe continuous gunshots or actively being pursued, right?
I'm not going to wait around to find out, man. In my testimony, when I heard the shots and I got out of my car, I was still 100% in fear for my life. And I didn't want to stick around to find out whether or not to be able to turn around and attempt to shoot me.
Okay. And so you were in such fear that you're able to mosey on to Ashley Sanchez's house, right?
I don't know what mosey means.
Walk on, run on, whatever you want to call it.
Yes, ma'am. There was a spike of adrenaline, and I mean, I was scared. I was scared for my life, like I said. And so, yes, I ran over to Ashley's.
All right. And so it's your testimony that you're in such fear, and there's multiple businesses there at the Brick at Blue Star that you could have ducked into and said, hey, I need help. Someone call 911. But you didn't do that, did you?
Well, no, because Lerma had already been past those businesses at the point when I was catching up with him. And so me thinking that Lerma was the only person in the wreck, that's who I was trying to attend to. That's the phone I was trying to get. And by the time we were already past the bridge, it was a dark neighborhood into the King Williams area. And that's why I ran, because I knew that I wouldn't be seen.
Okay. So at any time you could have returned back to the Brick at Blue Star because it's less than 500 feet from the bridge, correct?
Why would I do that? Someone is chasing me to shoot me.
Who's chasing you?
Diego Gomez.
Did you ever see him again that night? No, you did not. And then when your attorney is asking you.
Judge, I am going to object. She is badgering the witness and she is talking over the top of it. She's talking over the top of me, Judge, while I'm making a legal objection.
All right, so your objection is?
My objection is badgering and she's not allowing him to answer the question.
And my response to that is that the witness is being non-responsive.
Object to that then.
All right, the
Then he's not
objection,
responsive, Judge.
the objection will be overruled. Ask your next question.
Judge Boyd, please.
Did you ever see Diego Gomez again that night?
No, because I didn't stick around him.
Did you ever hear gunshots again that night?
Again, it would be no, because I didn't stick around.
Well, you were in the area, right? Because Ashley doesn't live that far from the Brick at Blue Star. Correct.
Correct.
Okay. And so when you're on that bridge, you're closer to the Brick at Blue Star than Ashley Sanchez's residence, correct?
At that point, yes, ma'am.
Yes.
I would imagine.
And so at that point, you could have gone into any number of those businesses, right?
I had already passed those businesses. That's what I was trying to tell you. And I was getting into an altercation.
What I am asking you is if you could have returned because you were closer to Brick at Blue Star than Ashley's.
Judge, on the objection calls for speculation.
Overruled.
This question.
You could have returned to the Brick at Blue Star from the bridge because the Brick at Blue Star was closer to you than Ashley's residence was.
Yes, I could have, but like I had mentioned before, I was.
Okay, so that's the answer. Yes, you could have. Okay? But you didn't, did you?
No.
So then, in such fear for your life, you continue down South Alamo, open to all of the elements and all of the traffic in that area, correct?
No, I had, like I stated before, you can visibly see that it was a super dark neighborhood. King Williams, they have a lighting restriction. That's where I went. And there's no lights on that street, on Madison Street. There might be one or two, and they're very dim. That's where I went because I knew it was dark there. And that's where I went and continued to run the Ashleys. Fear for my life is why I did not return back to the Blue Star premises.
But if you were in such fear for your life, so I guess my question to you is, Antonio Lerma's life takes precedent over yours?
What do you mean by that?
Is Antonio Lerma's life more important than yours?
Antonio Lerma's life? I mean, no, I would say we're equals, but at that point he had made his own decision to leave me in the car for one, and then for two to go his own way.
And so knowing that, you decide to chase after him instead of get yourself help in one of those businesses.
Yes, I wanted to make sure that he was okay, and I didn't have my phone on me, so
Okay.
I did try to attempt to use his phone.
But you didn't want to know if Mr. Moody was okay, correct?
How would I know? I didn't know I hit him.
Okay, well, let's talk about that. At what age did you obtain your driver's license?
I don't remember.
Was it when you were a teenager or grown man after you had kids?
I don't remember.
So how long have you been driving the Tesla prior to the crash?
It was prior to the crash.
Yeah.
From the time that I left the apartment.
I mean, was it months, years? How long have you been operating that motor vehicle?
Oh, couple of years.
Okay. And so you would agree with me that when you're operating a motor vehicle, even if you hit a rock or drive over a squirrel, you're going to feel and hear that, correct?
Yes, ma'am.
Okay. But it's your testimony to this jury that you didn't hear or feel when Mr. Moody flung up on top of your windshield and then into the burglar bars and then fell on the ground and died. Is that what you're asking them to believe?
Yes, ma'am, because it's the truth. I hit the median. That's what I thought I hit. After that, I was into a wall and I blacked out. Like I mentioned before earlier in my testimony, the first thing that's going on in my head is that I need to get out of there.
So it's your testimony that you did not feel or hear a 5'9", 191-pound male impact your windshield. That's what you're telling this jury today.
Yes, ma'am, that's the truth.
Okay. Now, you told your attorney that you couldn't use your mirrors. Is that correct?
Yes, ma'am.
Okay. But you could have, you just chose not to, correct?
Yeah, I mean, I could have with the risk of, at the time, of being shot, and I didn't want to be shot.
Okay, but we've all seen the state's exhibit. There was no risk to you because you were not being pursued. You agree with that, correct?
I don't agree because at the time I didn't know that.
I'm asking you what the evidence shows. You've reviewed the videos, right?
Yes, ma'am.
Okay. You were not being pursued at all because that Toyota FJ took a right immediately on South Fork, right?
Yeah, and then he turned back around. Yes, ma'am.
But you didn't see him.
The same way I didn't see if he was still behind me at the time.
There's no way to prove to this jury that that's the same motor vehicle. Correct.
Right.
And even if it was, you never saw it again after that intersection. Correct.
Because I did not return to the scene. That is correct.
Now, there was some testimony about the screen that is in your motor vehicle, correct?
Yes, ma'am.
Okay. And the Tesla motor vehicles are pretty high-tech vehicles, correct?
Yes, ma'am.
Okay, because we've seen that it has multiple camera views, right?
That would be correct.
Okay. And so, and the function that you testified to this jury about, it had live GPS on the right side of that screen where the music was, correct?
Yes, ma'am, that's correct.
Okay. And one function of the Tesla is that you can observe the cameras live while you're operating the motor vehicle, right?
That would be correct, but it would obstruct the view of the GPS.
Okay. And so you would agree with me that it would have been a more prudent and reasonable driving decision if you were in such fear for your life to use the live cameras than to rely on GPS.
Not at the moment, no, ma'am.
How not?
Well, because that wasn't the first thing going on in my mind, which functions to use. That's an automated, the GPS is just on there at all times, no matter what. You can't get rid of it. And so the first thing that's going on in my mind is just ducking down, trying to make sure that I'm not getting hit. I'm not thinking about what features my car has. I'm thinking about trying to save my life and not get shot.
And you're not thinking about anybody else on that road that you caused danger to that night, are you?
I mean, at that time, no, ma'am.
No, because you saw in the state's exhibit that there were multiple other pedestrians in the area, right?
Yeah.
Yeah, but you weren't worried about them or Mr. Moody, were you?
They weren't being shot at.
So what you are telling this jury is that your life is more important than everybody else that was on the road that night.
No, ma'am. I just made the decision that I felt was right at the time. The decision that I felt would best protect me and Antonio Lerma's life. And that's all I did. It wasn't to disregard other people's lives around me or people out that night.
But it was at the expense of other people, right? And ultimately, Mr. Moody lost his life because of it. Correct.
That is correct.
Okay.
All right. You done, ma'am? No?
So then, you testified that after you crashed, you were dazed and confused, for lack of a better term. Is that fair to say?
Yeah, I definitely blacked out.
Okay. And that you fall onto the ground, correct?
That is correct.
Okay. And then you're able to get up and gain your bearings, correct?
Correct.
And then follow Antonio Lerma.
More of a chase. He was already down the street.
Okay.
I was trying to catch up to him.
And so all of that I just described, you falling down and everything, happened in the 1 minute of Tesla video that's missing. Is that correct?
Objection calls for speculation.
Overrule.
Your Honor, we have no idea what's on that video that's missing.
All right, overruled.
Are you telling this jury that all of that occurred in the 1 minute that's missing from the Tesla video?
I mean, some more stuff might have happened, but at that point, I was already out of sight. I mean, I don't know what was on the video.
Okay, because you would agree with me that by the time the Tesla video starts rolling again, you're long gone from the scene, correct?
At that point, more than likely it's right.
It's a yes or no question, not more than likely. At the next video that we see, after your driver's side door opens, the next video that we see, you are no longer on the scene, correct?
Correct.
Okay. And so you have testified that there was only one person that could have been involved in this crash, and that it was Antonio Lerma, correct?
At the time, that's the only person that I knew that could have been involved in the wreck. Yes, ma'am.
Okay. And that you thought that you would just receive a ticket for crashing into the brick at Blue Star building?
I don't know what I would receive, but what I had found out later on that weekend was much more than I would have ever known. But for me, to answer your question, I mean, I thought it would have been, I don't know what I thought it would have been. I don't, to be honest with you, maybe a ticket, maybe more, maybe jail time, but all of that's, I mean, essentially better than what actually happened, which I didn't even know.
Okay. Well, let's kind of walk through that a little bit, because you told Mr. McLean that it was your intention to leave the motor vehicle there and receive a ticket for property damage. You recall saying that?
Something along those lines.
Okay. And so you're aware that even if you cause property damage in a crash, you have a legal obligation to notify the owner of the property that you damaged, right?
I did not know that until now.
Can I have parties approach briefly?
Judge is about to call a break and announce that she just finished her new Sudoku. Karen, I'm with you. I think she's made some incorrect calls here, and I can't quite wrap my head around it. I still like her. She's wonderful. She's amazing at what she does, but it seems something else is on her mind. There have been, I mean, the questions to ask for the witness to speculate about what someone else was thinking. That's an easy one that she got wrong. Speculating about what's on a video that we don't have. I'm pretty confident now that should he get convicted, he's got an easy shot at appeal now. But maybe the jury is going to take pity on him, because it seems like everyone's ganging up unfairly on him. So if we don't like the prosecutor, I think we're commented equally. Let's be kind for sure in what we're doing. Looks like they're standing up for the jury to leave. Yes, this might be a little break. See if the judge comes back on. We get the bottle back on the camera. Somebody's talking. We can't hear it. Good old HEB water. Glug, 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 glug. Phone's in the outer pocket. Who's he texting when he's on the stand? Tomorrow morning, 9 a.m. Mountain Time, there's a Tyler Robinson hearing. Just got the update and the info on that one from the courts. So KUTV's pool on that one. It's weird because it's their pool, even though it's WebEx, which is just funny. But we'll hold up and see what the pool feed is. Yeah, we want to follow that one as well. I'd rather catch up on this case instead. He took his water. Yeah. I tell you, I'm struggling to like a lot of the things I'm seeing in this court. The defendant, for sure, I think is not telling the complete truth. He's not coming across as believable to me as he's telling his story about how things went down and what happened. I think it's very convenient. It doesn't match up with the whole, I was worried for my life, and as soon as we got in a wreck, I just thought, oh, the car will take care of itself. I don't have to, 2 days, basically, 48 hours, because this is like just after midnight when the wreck happens, right? And then all that day, and then into the next day, he doesn't even call the police. Still, to this day, never called the police about this. He does turn himself in, but only after surrounding himself with friends and family and hugs and seeing everyone and saying goodbyes. There's a consciousness of guilt aspect that seems to be at play there, more than just, oh no, I hit a building and ran away. The testimony that came from this witness, when he said he went to his friend's house and the girlfriend says, "You look like crap." That's the sort of statement that would be said about somebody who was drunk, right? Not like, man, looks like you just ran for the last half mile. Things aren't adding up. And the judge just took down the live stream again. On break again. Fun times. They're trying to take the phone. Be careful, I'll get in trouble. Why am I going to get in trouble? He's testified that every week they reward their employees this way. They go out to all these establishments that serve alcohol, but his testimony is that basically they weren't drinking, or he wasn't at least, and he wasn't buying drinks for anybody. But we saw, at least 5 screwdrivers, right, were purchased by somebody that night. Karen, by the way, I think I subscribed to your channel. I want to see some of the videos you put out. I want to hear you break it down. So hopefully I subscribed right. I mean, it is YouTube. I should figure out how to do that. Yeah, I'm subscribed. Can't wait to see you break down another one. Let's see. I don't buy into his excuse for the accident. Red, here's what I think, because he's telling this story and he's like, oh, we pulled up and he pointed a gun at me. I can see all this happening, right? I can see a brandishing of a firearm, even shooting at him, and ducking and running type thing. The problem is the way he tells his story about how I'm the white knight, just here to celebrate the hard work of my employees and nothing else. I have nothing but just the success of their stores on my mind, and I'm a good driver and good citizen. And he's like lane changes all over the place, and he runs a red light, and he pulls up next to the car that ran a red light, and he's like, I was catching up to him. He was trying to catch up. I don't believe that gun just sat there in his center console and did nothing else. I just don't believe it. So I think he was, in fact, causing the situation, which then he tried to flee from. And anyone who's taken concealed carry classes knows that generally the way the laws work, you can't create a situation and then use it as defense, and you had to flee for your life and say, oh, my actions are justified because I was in danger. Well, if you created it, it's your own medicine coming back at you. I think it's very well rehearsed. Too many times he's inserted I was in fear for my life. What a reasonable person would do. For him saying, what did you do right after the crash? Well, I thought to myself, what would a reasonable person do? You did? You're like, well, self, what a predicament we have ourselves in. Just taking stock of the situation, it appears I've just wrecked my car into a wall. My passenger is not here. He's exited and closed the door. I'm not feeling the best. What would someone else do right now? That's his story on the stand. That's his testimony. Yeah. SF in Texas says, I disagree. I don't think he started it. I'm not sure if starting it is the right word. The FJ running the red light might have started it. Or maybe they were racing before then, and before the red light. I don't know. We just don't know what happened there. We know that the Tesla was passing all the other vehicles before then, and it was going faster than the other vehicles. But when they got to the red light, the FJ runs the red light, he runs the red light, and at that point he describes it as he's trying to catch up to the FJ. Why? He is not a police officer, right? Why is he trying to catch up and then pull up alongside somebody who you just spotted doing something wrong? I think that is not what a reasonable person would do. I don't ever see an FJ ever keeping up with the Tesla. Right. An FJ is a Toyota SUV model car. Yes, think of like what's a comparable vehicle? Like I don't know, Jeep Grand Cherokee, but they've got like a unique top. They're sort of a unique design. I don't understand the red light thing to begin with. Yeah, why he ran it and then describing it as like, well, I pulled up to the red light and after checking to make sure it was clear, I ran the red light too, like a good citizen would do. The Hummer 2? Okay, yeah, I can see that. A scaled down Hummer 2 is the FJ. Am I correct? He left the firearm at the scene. Yes, I believe so. I believe it was in the vehicle still. It's a small Land Cruiser. I've done that red light thing before. when were you chasing someone? I mean, I've run a red light. I ran a red light on a live stream once. That was the last time I drove while live streaming. In that scenario, with me being the driver and managing the live stream, not a good thing to do. You guys watched it. I mean, in that case, I did. I pulled up, I checked both ways, and I ran the red light. And there was too much on my brain. I shouldn't have done it. Won't tell you what state that happened in, because the statute of limitations might not have expired. Not chasing one, but since the other person went, I went too. Sometimes when you're in like just the follow mode, right? You're driving, but you're sort of on autopilot. And when the car in front of you is very confident about the move it makes, even if it's illegal, you might also make the same one. I've been in that trap. Toyota FJ Cruiser is a retro-styled body-on-frame SUV known for its strong off-road capability, featuring a 4-liter V6 engine, available 4x4, and rugged design with round headlights and fog lights on the grille. Yeah. Interesting. This is our afternoon break. Not sure if we're going to get to a verdict watch or not. There are some other witnesses that the defense would like to bring in, or at least there's some argument I'd like to hear about them bringing in other witnesses, specifically the video of 2 people in the area at the time this happened that supposedly they made this video when it was sent to the police, and the video has something to do with the fact of them saying, we heard gunshots and then a crash, and the state did not want this in. The state did not want this in. They were not going to admit it. They did not do any digging into this at all. Defense would love this to be in. As I have to say, I don't believe the prosecution on this one. When they're like, but you don't know it came from
Remember
the FJ.
in the beginning when we started 110 years ago?
Exactly. Do you see the Legal Eagle is in Dropout Game Changer this week? I don't even know what any of that is. Let's jump to another court while we wait on break. Oh, that's not it. Let's try this one.
With the services and advice given to you by your attorney?
Yes.
Now, this guilty plea that you're attempting to make hasn't been based upon any threat or promises as to what this court will do in regards to your sentence or any other type of threat or promise?
No, sir.
You understand that if there are any plea deals between your counsel and the county attorney's office regarding sentencing recommendations, that this court is not bound by any agreements made. The court may and shall consider them as recommendations, but is not bound by them. Do you understand that?
Yes, sir.
So let me ask you formally, how do you plead to the charge in count 1, possession of methamphetamine?
Guilty.
Ooh, that's a bad one.
According to the state's charging document, Ms. Beckman, this took place on or about October 29 of 2024. Is that when it happened?
Yes, sir.
And it happened somewhere in Butler County, Kansas. Where was it?
On Kellogg.
Okay. On Highway 54. So part of it goes through Butler County?
It's between Butler County and Wichita.
Okay. I have to establish that it took place within Butler County. So was it?
Yes, it did. Sorry, yes, it was in Butler County.
Okay. All right. Fair enough. And they allege in count 1 that you were in possession of the controlled substance methamphetamine. Were you?
Yes.
Where was it, Ms. Beckman?
It was in the car.
Okay. Did you know it was in the car?
Yes.
Did you know it was methamphetamine?
Yes.
Do you have the legal right to possess methamphetamine in the state of Kansas?
Yes, sir.
So do you now freely, knowingly, and voluntarily enter a plea of guilty and accept conviction for count 1's charge of possession of methamphetamine, a level 5 drug felony?
Yes, sir.
All right. Mr. Baca, do you know of any legal reason why the court shouldn't accept Ms. Beckman's plea?
I know of no legal reason, Your Honor.
Mr. Watts, are you aware of any such legal reason?
No, sir.
Ms. Beckman, do you know of a legal reason or any other good reason why the court shouldn't accept your plea this afternoon?
No, sir.
Court will accept the guilty plea made by the defendant and finds that that plea is made voluntarily. She has an understanding of the nature of the charge against her and the consequences of the plea. And a factual basis for the plea does exist.
How many
Court
names are
finds her
Mr.
guilty.
Watts'
The
name?
judge is
How many
convicted
T's?
of possession of methamphetamine, a level 5 drug felony. All other counts of the information are dismissed pursuant to plea agreement. Court orders a pre-sentence report be completed to accurately determine Ms. Beckman's criminal history, and the court will set an appropriate date for sentencing.
He's got too many T's in his name. Mr. Watts.
Mr. Watts, would you check your calendar for Monday, July 13 at 11 o'clock?
Judge, I'm going to be singing at a folk convention on this here guitar. Do you mind if I sing the song for you now?
Very well. The Beckman sentencing is Monday, July 13, 11 o'clock a.m. Ms. Beckman, you handled Zoom from your car fairly well today, but for sentencing purposes, the court's going to order you to appear at the Butler County Judicial Center in El Dorado, Kansas, and no other location. Now, it is contemplated to be done by Zoom, but you need to physically be at the Judicial Center in El Dorado to participate, all right?
So it's going to be on Zoom, but I need to be at the courthouse?
That's correct.
Okay. I can do that.
Monday, July 13th at 11.
And ma'am, stay away from
Okay,
the meth.
further, Ms. Beckman, I'm going to continue you under your current bond, but with the additional conditions that you comply with the pre-sentence investigation process, you are likely to be asked to do one or more assessments, a risk needs assessment, and a substance abuse evaluation of some kind. It is up to you to make sure that those get scheduled and completed so that there's no delays in your sentencing. So
You have those done before my next court date? Sorry.
you sure do. So here's what you need to do. You need to contact Butler County Court Services this afternoon. Okay?
Did you say this afternoon?
Yes?
Okay.
You can do that by telephone, Ms. Beckman, but
Okay. Yeah.
you should contact their office. Area code 316.
867-5309.
And I just to tell them that I need to do what?
That you entered a felony plea today to possession of methamphetamine, and the judge told me to contact your office.
Okay.
They'll take it from there. They'll let you know what
do.
you need to do next to facilitate the pre-sentence process. Okay?
And Blair, generally they're watching this, so they're probably expecting your call.
Okay.
They're like, yay, a new customer.
So again, 322-4.
867-5309.
Right. Ms. Beckman, any questions or concerns about what we've done here today?
No, I don't think so.
Mr. Watts, anything further?
I don't believe so, Your Honor.
Mr. Baca?
Nothing from the state, Your Honor.
If you're free to do it now, I would just suggest, Ms. Beckman, as soon as we get off the meeting, go ahead and make your call to court services.
Do
Okay?
it.
Okay.
All right. And if there's nothing further, the Blair Beckman matter will be in recess at this time. We'll move on to another case.
All right. Thank you.
Probably Butler County
Mr.
Detention.
Watts, does that conclude your portion of this docket today?
I believe it does, Your Honor.
Thank you, Mr. Watts. I'll move on to Mr. Favre's case.
Mr.
Have a good
Favre's
afternoon.
here.
You too.
Mr. Favre. Everyone's driving today. Everybody's
All right,
driving.
Mr. Favre?
Judge, let's clear the jail out first with Mr. Smith.
Okay.
Let's clear out the jail. We're waiting for Judge
State
Boyd
of
to come
Kansas
back.
versus Dayton Allen Smith, case number 2026, CR 140. Dayton Smith?
Yes, sir.
Okay. Appears at the jail Zoom location. Joseph Favre is defense counsel, separately
Jail
from
library.
his client. Joseph Baca appears for the state of Kansas. What announcement is made at this time regarding preliminary hearing right?
Judge, we would like to set this for an evidentiary hearing at this time.
Request discovery.
Okay.
Motorola G.
Does Mr. Smith have other holds on him?
He does, Judge. He's sitting there with the DOC hold currently.
DOC, Department of Corrections. That's not good. Those folks can be weapons.
Looking at July 15th.
But Judge, I'm going out of town for a couple weeks in the middle of July, including that whole week of the 13th to the 17th.
Mr. Favre, where are we going?
Try to take vacations. My wife insists on it.
Yeah. Where are we going? That's what I'm asking. Where are you taking us?
June 24th at 10. Mr. Favre?
June 24th is fine. I'd prefer the afternoon if there's any afternoon slots.
I'll have to ask my assistant about that. Doesn't appear to be, from what I can see.
Judge, we are packed in the afternoon.
Okay, let's do 10. That's fine.
Okay.
I'll make it work.
You don't have a current conflict there?
I don't know. It's a Friday morning, so it's pretty busy, but I'll just put this first and we'll just make this work.
He's all judge.
Okay, it's actually a Wednesday morning.
I'm sorry, you said the 24th? Oh, I'm looking at July. I'm sorry. Oh, July 24th at 10, I'm fine. That's fine. My mistake. I was looking at the wrong day.
Make sure we're on the same page here. I'm looking at June 24 at 10 o'clock in the morning.
Yes, Judge. I'm fine at that time.
Okay, very well.
He said, Judge, you know me. I'm a
Ayden
workaholic.
Smith's
My wife.
evidentiary hearing is set.
She wants me to take a vacation.
At that time. That'll be conducted by Zoom. Wednesday, June 24, 10 o'clock a.m., Zoom evidentiary preliminary hearing. All right. With that now set, Mr. Favre, is there anything else we need to address currently regarding Mr. Smith?
Yes, Judge. Mr. Smith would like me to address the issue of his bond.
There's something else.
He currently, as I noted, is sitting in the jail with a KDOC hold. He's anticipating being released out of KDOC when he checks into them. I understand, like a parole hold of some kind. And so he thinks he'll do just at most like a 90-day sanction, but he thinks he'll be released. He would like me to ask the court to modify his bond to a lower amount so that he can get that process and then come back out. He's expecting a child to be born soon. I think he said in August. And he is presumptive probation on this. He is currently on a $10,000 cash or surety bond, but the bondsmen aren't willing to touch him at that amount. We're asking for the court to consider an OR bond or at least a lower cash or surety.
What's the state's position here, Mr. Baca?
But Judge, I believe the bond's appropriate. The defendant has several convictions that involve firearms, a couple felonies, including possession of a firearm within 10 years out of Sedgwick County in 2022, including another one in 2023. And then here we are with the charges before him today. So there is a concern about public safety here, and I feel the bond's appropriate given his history and the allegations.
Judge, if I could just make a real quick comment on that. I know we're not trying the case, but I think it's important to note when assessing the public safety risk that the allegations, even if they were proven true, which again, they're not yet, would be that the guns in question were being used at a private property. The property owner knew that the individuals were there. They were not being used in a dangerous public manner, even if he was found to be guilty of this. So I just want that to be weighed in when you're assessing safety risk.
You just admitted they were being used.
Where is Dayton Smith from? Where is his primary residence?
I'm not exactly sure. Mr. Smith, where are you from?
Wichita, Kansas, sir.
Wichita, Kansas?
Court will grant partial relief here. Court will set bond in this case at $5,000. Cash or professional surety required. Obviously, with no weapons, no drugs or alcohol. Restrictions and appearing on time for every single future court date, including the prelim that we set today, 10 o'clock a.m., Wednesday, June 24th. Mr. Smith, if you make bond, you're going to be required to appear at the Butler County Judicial Center in El Dorado on June 24th, no other location. If we do it by Zoom, you still participate from the detention, either the courthouse, because I'm presuming bond has been made. So you'll have to appear at the Judicial Center in El Dorado and participate from there. Court security does an excellent job of making sure that defendants can fully participate in those hearings.
They're great.
Okay.
Excuse me, sir. Can I say something?
You can say something.
The attorney's
if
like,
I was to
nope.
bond out today, I still have to go to KDOC. So I don't know how that will work.
Well, how long would you anticipate you'd be in their custody?
90 days.
90 to 120 days.
Okay.
But what the bondman won't bond me out unless because of court dates. He don't want me to miss a court date.
No. Are you fearful that you'll post a bond in this case, then get released to KDOC, and then, well, okay, we can work with KDOC as long as we know where you are.
Yes, sir.
Most of the institutions work well with us.
Yes, sir.
Get you into a room.
Yes, sir.
And so obviously if you're in custody, we'll have to work with your custodial arrangement to get you to those court hearings.
Yes,
by
sir.
Zoom. Okay?
Yes, sir.
Just make sure your attorney knows at all times where you're at.
Yes, sir.
Okay. All right, Mr. Smith, legitimate concern.
Good question.
Anything else we need to address here regarding the Smith case?
No.
No.
Nothing from the state, Your Honor.
Mr. Favre?
No, Judge, not this time.
Dayton Smith's matter will be in recess at this time.
Thank you, sir.
All right, we're waiting for Judge Boyd to come back from break.
I don't think we've actually cleaned out the jail, Mr. Favre, but I think we're ready to move on to some other people.
That's fine, Judge. The last three I have should not be in custody, all three of them, and that would be Mr. Riley, who's present. We can take him up next.
Okay.
Your Honor, we don't have anybody else at the jail unless there's somebody that you have on your list.
All right. I don't anticipate that there's any more jail cases on the docket. Would you agree, Mr. Favre?
I don't have any. Nope.
Very well. Then I can go ahead and release you.
Thank you.
Jail.
All right,
Thank
court
you.
security's gone. We'll shuffle everybody.
Okay,
in
Brian
this
Riley.
Your Honor.
Okay.
And this is
So Riley, your Zoom instructions really tell you to put your name into the box so that we can tell who's on the meeting rather than Motorola, Moto G, which I doubt is your name. So please, in the future, if you would make that accommodation. This is State of Kansas versus Brian James Riley. It's case number 2026 CR 105. Mr. Riley appears on his own Zoom. Joseph Favre is defense counsel. Joseph Baca on behalf of the state. What announcement is made here, Mr. Favre?
Judge, at this time, Mr. Riley would ask that this be set for an evidentiary preliminary hearing.
Very well.
Is that what he wanted, or is that just what you do with every case?
Check your calendar, Mr. Favre, for Tuesday, June 23.
Mr. Motorola.
You have a puzzled look, Mr. Favre.
Yeah, I'm trying to figure out why that showing is oh, that's why. I'm available that morning. I have a bench trial that afternoon in Augusta City.
All right, I can set this at 10 o'clock on the 23rd.
That's fine.
Okay.
It's the quietest place they know.
The Riley preliminary hearing, it's an evidentiary preliminary hearing, will be set. We begin at 10 o'clock a.m. Tuesday, June 23. Brian Riley, where do you reside?
183.
123 Sesame Street, anywhere, USA.
You're sitting in a car, so I trust you have driving abilities and privileges, correct?
I do. Yes.
Yeah, I'm going to want you at the Butler County Judicial Center in El Dorado for that next hearing, as it is going to be an extended hearing involving evidence. Works best with you at the Judicial Center with a security ran location. So Tuesday, June 23, 10 o'clock a.m. for evidentiary hearing. Mr. Riley being ordered to appear at the Butler County Judicial Center in El Dorado for his participation. Mr. Favre, anything else we need to address on Mr. Riley at this time?
Not at this time, Judge.
Mr. Baca, anything further from the state's perspective?
Nothing from the state, Your Honor.
Very well. Then if there's nothing further, the Brian Riley matter will currently be in recess. Mr. Riley at this time is free to leave the meeting.
Does that finish up your docket, Judge, or do you have somebody else? Do you think it would make him frustrated?
I think I see Crystal Ivy on here.
That's correct, Judge.
Do you think the judge would be frustrated if people are like, "Oh, I'll stick around and watch"?
Crystal Ivy, if you'll join fully.
commit, Crystal. Join
Ms. Ivy?
fully.
No.
Okay. This is State of Kansas versus Crystal Dawn Ivy. It's case number 2026 CR 94. Crystal Ivy appears on her own Zoom. Joseph Favre is defense counsel. Joseph Bach on behalf of the state. What announcement is made here, Mr. Favre?
Judge, I have a little bit of an unusual announcement for this division, but I'm going to ask the court consider setting me for one more PHC on this, only because there was some miscommunication with the CA's office regarding discovery. When I got the case from Mr. Watts, he told me it was going to be sent to me by DocuShare directly from the CA's. Normally it goes through his office.
Gotta love DocuShare.
It was never sent directly from the CA's, so I'm still without discovery on this matter, unfortunately.
Did they know of your involvement in the case?
They did get emailed on it. I will double check, but yeah, I'm pretty sure they did. I think Cheryl had
What is your office's position on this request?
Judge, I do know, I believe this is the first request Mr. Favre has made on this. I was checking on that discovery. We do have a letter that went out March 24th about the DocuShare that our office does.
Not DocuShare.
So if you're looking for a date, that's when it went out. But I have no objection since it's the first request that Mr. Favre has made on this.
All right. And I know at least for the purposes of this docket, it will be the last request. I can reset this to Monday, June 22. Therefore, you're going to have a matter in this court 3 consecutive days, Mr. Favre, which I'm sure you're fairly excited about.
Brings me a lot of joy, Judge, yes.
I'm sure it does. Mr. Favre and Ms. Ivy, we're going to reset this to Monday, June 22 at 2:30.
Let's jump to another court, shall we?
Ms. Ivy?
All right.
Sorry, Miss Ivy.
Mr. Myers, you're before the court this afternoon for an arraignment in case 26L 000684. In this case, the city of Lakewood has filed a criminal complaint charging you with 1 count of assault in the 4th degree domestic violence and 2 counts of exposing a minor child to domestic violence. The city of Lakewood alleges in that criminal complaint that these crimes occurred on or about May 16th, 2026. Ms. Ruiz, are you prepared to proceed with Mr. Myers' arraignment at this time?
Yes, Your Honor, and we're not seeking an appointment at this time, but we do request to appear as friend of the court today.
That would be fine. Thank you.
I have advised him of his rights, and I do believe he understands them. We waive formal reading of the complaint, stipulate to probable cause for the purpose of this hearing only, and enter pleas of not guilty. Thank you.
Thank you, Ms. Ruiz. Mr. Myers, based on that request from Ms. Ruiz, the court's going to waive formal reading of the criminal complaint, find that there is probable cause to support the filing of these 3 charges, and enter pleas of not guilty for you to each of those 3 counts. Court is next going to hear from the prosecutor, Ms. Warner, regarding her recommendation on the issue of pretrial conditions of release.
We're going to jump.
How would we know? That's reasonable doubt. And if you have that by the end of the case, I would say you should go with not guilty. You should find the defendant.
It's but fabulous hair, jury.
If you have doubt, but there's enough evidence or facts that stipulate that you show that doubt really isn't reasonable. So let's put it in that same situation. A witness sees a person stealing from across the street, but this time they also see that person wearing bright red, distinctive shoes and a bright yellow construction cap. And then about an hour and a half later, the defendant in this case, or in that made-up case, is arrested 3 blocks away wearing red shoes and a bright, distinctive construction hat in his vehicle. We can't know for 100% certain if that person is the same person that the witness saw, but what's the probability of another person having bright red shoes and a construction hat at the same time near the same location? You can still have a doubt, but the facts suggest that the doubt is not reasonable or probable in that case. That's how I would think of beyond a reasonable doubt. Let your common sense and your regular sense of judgment guide you in making that determination. Lastly, 2 points. Does anyone hold any religious beliefs that might prevent them from sitting in judgment of another person? You know, there are some religions out there that they just think only God should judge somebody. Does anyone feel that way? Right.
No hands.
And is there anything else that I haven't asked you about or that we haven't talked about that you think I or the defense should know about you or anything? All right. Thank you so much for your time. I look forward to those of you who are reflecting on the
If Fabio went to law school, this
Okay,
would be
Mr. Cole, you may proceed.
Wow, 2 fantastic examples of hair.
Yes, you may proceed.
It's the duel of the shampoo.
Well, first of all, I've been dating wrong. I have. I mean, I got a lot of hands here that said that if they caught their significant other in the bed with someone else, that there'd be no physical contact. So I need to restructure my training thing. I know if I got caught, I'll probably lose a arm, a leg, or something like that. So hats off to y'all that have restraint, and that's pleasant if everybody had that moving out these type of cases. So hats off to y'all. My name is Giles Cole. I'm from Orange, Texas. Went to West Orange Star. Went on to Texas A&M Kingsville. From there, practicing law in this area. And I love it. This is the fun part for me. I have 2 kids. One's 22 years old. She's in Miami. And I have a daughter that's 9 years old. She's living in Shreveport.
This is the
And
lawyer.
the reason I'm saying all this to you is because I want you to know a little bit about myself. Because, of course, I'll be asking you a few questions. So it's only fair. How many of you have kids? Okay. Mr. Wyckoff and Mr. Gregory, Ms. Simon, Bell, Gage.
Still trying to find Judge Boyd.
I tried to figure
She's
out
on break.
that. What is that?
Check.
Check. That's the first check person I've met.
Yeah, there's supposed to be a little housetop above the C. You know, when we were in grade school, that's how we were taught. The C had the CH sound, and at some point, the little housetop went away.
Well, I want to make sure I remind them next time we get a check back.
But the little housetop
That's right.
above the C.
That's right. When dealing with your kids, right? If you hear one of the kids crying, you run out the house, you run to the door where the kid's crying, and he said, "Daddy, Mama, my brother hit me." Do you automatically take that kid's word for it, or do you take time to hear both sides of the story? Which one do you do?
Hear both sides.
You hear both sides, all right? You don't automatically spank the one who's not crying, right? You want to hear what's going on. So, pretty much, that's what I'm asking here. That you hear both sides of the story. My colleague here went over this is misdemeanor court, and of course we don't have a grand jury. Not indicted by a grand jury, so there's not too much of a vetting process, if that makes sense. So a lot of these cases come through here, not having the privilege of going through a grand jury, if that makes sense to you. So we ask that you take time out, see both sides of the story. Now, I can tell you our side of the story. And that Mr. Brown is still trying to figure out why he's here. Our side of the story is that he was defending himself. And I think to put this in context, this isn't husband against wife. And this is scary for any of you that are believers. This is father against child. You see. And Ms. Viator, you're an educator.
Yes.
Mr. Murdoch, you're a counselor. And Mrs. Murdoch.
Not related.
Oh, right. 2 counselors, psychologists. Are you dealing with our youth?
Not. Oh well, I say that I'm at least teaching college.
College?
So if you consider that youth, yes.
Okay, yeah. So what about you, sir?
Yeah, my caseload is mostly kids.
Where are they from?
Say from about age 4 to 17.
Okay. How long have you been doing this, practicing?
Well, I got my master's degree in '93, and then I moved to Texas, and I've been a professional counselor since 2002. I'm also a certified school counselor, so I've done that as well.
Have you noticed any changes from when you first started to here?
Yeah, lots. Yeah.
What about you, man?
Oh, yes, sir. High school.
High school.
Well, all elementary and middle school and for the last 4 years, 4 to 5 years, it's been high school.
You know, I'm 50. Okay. 76, I was born, raised in the 80s. And I can tell you that things have changed, both with men and in particular our women. I see a lot more aggression now than ever before in our youth. And so that's what we're dealing with right now.
Yeah,
now,
we're going to bail from this in a
my
minute.
job
We're just hoping that Judge Boyd came back.
Mr. Brown. Now, how do I vigorously defend my client? Mr. Trott, how do you vigorously defend? If you were me, how would you vigorously defend
How should I do my job?
How do you do about doing
domestic violence case?
Yeah, do you ask tough questions? All right. Do you sometimes have to dig into police officers a little bit? I would say something. Maybe even a lot. Because you're doing your best to protect his constitutional right to a fair trial.
All right, we're going to jump one more.
So this is Mr. Lawson coming now. So if we can go off
Fulton
of the
County.
YouTube.
Oh, they went off YouTube right here. Nice. Perfect. Let's see. Still no Judge Boyd. And her break has now been 38 minutes long. I'm not sure if she's... When did she end yesterday? Did she end early then too? I thought she did. So a couple things. We got Paul Canero. That's brother against brother. Remember the house fire and the shooting, and the wife and the kids also killed in the house, and then the house set on fire. Then he went back to his own house and lit it on fire, but his family all escaped. We've got that sentencing tomorrow. We also have Tyler Robinson tomorrow, and then I assume we're going to continue with Judge Boyd. It's only 3:30. She's just not coming back. Let's jump up to Thurston really quickly, see what's happening up there. What is that the inmate guy's holding? Is that a wristband? Hey, Christine, welcome. We're just waiting for Judge Meyer. Then we'll have a little hearing. I've always thought it was strange how the jail puts the inmate and the attorney side by side in a padded room and says, "Go at it. We'll check on you every once in a while, make sure nothing goes wrong here." City of Tumwater Fire Department says hi. Big shout out to Tumwater Fire Department. You guys keeping it cool when it gets hot. Appreciate that, y'all. Got a lot of respect for firefighters and the toys they get to play with. The firefighters first exposed me to the whole idea of a thermal camera. And back in the day...
Looks like I was spelling her name wrong. Sorry, Thunder. Oh, hold on. I'm going to unmute.
You're unmuted right now. But they had, I think it was a FLIR at the time, but it was the thermal camera they had that allowed them to look, at the hot spots in the walls and things like that. It was like the size of a shoebox, like that an oversized pair of Michael Jordans would come in. Oh, judges come in.
Guys, there's something disregard a sound session. Judge Sam Meyer presiding.
You can be seated.
We do accept firefighters.
That way, it looks like they never even put Referral destination application.
Yeah, Ms. Shannon, I wonder if you could mute your microphone, please. Thank you.
Oh, yes, sir.
Oops. Judge Meyer, welcome.
Ms. Myers, who's seated next to you up in custody?
Your Honor, this is Mr. Michael Anderson. He is number 1 on the calendar. We're here for a preliminary hearing.
He's number 1.
Give me just a second here.
Is Ms. Myers related to Judge Meyer?
Is a preliminary appearance on a domestic violence related matter. What's the state seeking probable cause for?
It's all 4, Your Honor.
And then Ms. Myers, do you have a position on probable cause?
Your Honor, we'll be reserving any argument on probable cause for the purposes of today's hearing. I have advised him of his rights. I do believe he understands them as they've been explained to him. We are not asking for our office to be appointed. He is not eligible. However, I have advised him that if he seeks private counsel and cannot afford it, to repetition the court to have counsel appointed.
She is public defender. He is earning too much. I'm actually looking to get a thermal camera right now.
I logged into the wrong courtroom here.
We're looking at getting a thermal camera for live remotes, which would allow us to continue filming events even at night once it gets dark and you can't see anything anymore.
Is he seeking court-appointed counsel?
Your Honor, he is not eligible for the public defender to be appointed.
And then you said you were not challenging probable cause at the moment.
That's correct.
And so, Mr. Anderson, I'll find probable cause for assault in the 4th degree, domestic violence related. That's a gross misdemeanor, which carries with it a maximum penalty of 364 days in jail and a $5,000 fine. We're going to set conditions of release. We're also going to set an arraignment within 3 days. And then I'll hear from the state on conditions. Then I'll hear from Ms. Myers.
Yes, Your Honor. State is asking, has no objection to a PR release with the conditions of no new law violations, no firearms or dangerous weapons, and the granting of a no contact order that does have a civil standby.
Ms. Myers?
No objections, Your Honor.
And then did you provide a cell phone for text reminder purposes, Ms. Myers?
I did, Your Honor. At this point in time, we do not have an address to provide the court. He will be looking for a place to stay.
Right. So, Mr. Anderson, you're going to be released on your personal recognizance. Conditions of your continued release are don't have any criminal law violations, don't possess a firearm or other deadly weapon. Also at this time, I'm going to sign a no contact order that forbids all contact from Kathy Anderson. No contact means no contact. You understand that?
Yes, assuming as I can get my property with a cop present.
Oh, careful.
My daily driver I need for work and my computer.
Let me talk for a second.
Yes,
and then I'll get to that in a second. But when I say no contact means no contact, that means no calling, no texting, no emailing, no telling a third party acquaintance to go tell her this or that. Any of those things would be considered a violation. Included in the no contact order is a one-time civil standby for you can go by with law enforcement for reasonable time and duration to get your personal belongings, those things you identified there. So there will be a civil standby that you can get those things. All right.
And can I ask a question, sir?
Yes.
Can I do that today? Because I need my work computer and my vehicle.
You're going to have to coordinate that with law enforcement. By the time you're released, I'm not going to mislead you. I tend to doubt that will be able to happen today. Maybe, but you could contact law enforcement as soon as you're going to get out. It could probably happen tomorrow, I would think. Ms. Myers might be able to provide more insight to that, though, to tell you the truth.
Thank you, Your Honor.
And your next court date will be on May 21st. That's on Thursday. It'll be at 1:30. And that'll be it for today. You'll get released here later today.
Okay.
Thank you, Your Honor. Your Honor, at this point in time, I would be requesting, I'm going to set up a breakout room with me and Madam Interpreter if we could have a moment while we're at the jail.
Okay.
The breakup thing might already happen on its own due to the nature of the charges, but the breakout
Happy
room,
to. Thank you, Judge. Hi.
it's different.
Hello. And then what's your name out at Nisqually?
Your Honor is Mr. Christopher Wangui Mungai. His number today's calendar is here for arraignment.
What's going to happen?
Judge Boyd's still not back yet. Not sure if she's coming.
And then
back.
Mr. Gray, we're going to take this case, then we'll come to your case. You're welcome. Did you say this was Christopher, is that Wangui?
Wangui Mungai.
Wangui.
Yes.
We got
yes,
it.
Your Honor.
It's a tough name to pronounce.
So you're Christopher Mangui?
Yes.
Okay. This looks like an arraignment
Yes, Your Honor.
on a domestic violence related offense. Is this his first appearance?
Yes, Your Honor. It is.
And then, so Mr. Wangui, based on, where do you work?
Work with Acres, which is formerly, it was there for Acres. Right now it's in Dungarvin.
Say that again, please. A little bit louder, please.
Dungarvin like a Dungarbin. It's a health issues company.
Okay, what is it exactly you do?
I'm a DSP, kind of like a caregiver.
So, did you review your legal rights on this sheet of paper?
You say ESP?
Sorry?
Did you review your legal rights on this sheet of paper here? It looks like your signature's on the bottom of it.
I signed on his behalf,
Okay.
Your Honor.
Did you review your legal rights with Mr. Marembe?
Yes.
Do you have any questions about any of them?
No, please.
I'll appoint Thurston County Public Defense to represent you, but I will require you pay, given the amount of money you make, you're kind of on the edge. I'll require you to pay $200 to help defray the cost of court-appointed counsel, but I will appoint Thurston County Public Defense to represent you.
Yes.
Did you have a position on probable cause?
Yes, we're stipulating as to probable cause, Your Honor.
You're charged with one count of assault in the 4th degree domestic violence related. That's a gross misdemeanor and carries with it a maximum penalty of 364 days in jail and a $5,000 fine. Plea of not guilty will be entered. This matter will get set for future hearing. Well, no. Yes, it will, because this is an arraignment. And I'm going to hear from the state on conditions of release, and then I'll hear from Mr. Marembe.
Yes, Your Honor, the state has no objection to a PR release with the conditions of, no firearms, dangerous weapons, no criminal law violations, and the granting of a no contact order that should be in the judge's folder. There is a civil standby request as well.
Mr. Marembe?
We have no objection for those release conditions, Your Honor.
Okay. What's the relationship between
Roommates, Your Honor.
They are roommates.
They're roommates?
Yeah, they are roommates.
Okay.
Oh, yeah.
So, Mr.
Roommates got
Wangui,
no
you're going to be
fight.
released on your personal recognizance. Conditions of your continued release are don't have any criminal law violations.
Yes.
Make all your court dates.
Yes.
And don't have any contact with Catherine DeDuth. You understand that?
Yes, sir.
And we'll see you back here on June 24th.
Yes.
At 10 a.m.
Yes.
I hope he understands everything. I mean, I realize if he's still in custody.
And Mr. Marembe, did you provide a cell phone number for text reminders?
Yes, Your Honor, I did.
That's it for today there. You can be taken back. You'll get released here later today.
Thank you so much.
You're welcome. And Mr. Gray, you can come on up.
Christine's waiting for her turn.
This is for arraignment for Miss McCullough.
number 5, I believe.
I believe you're correct.
Christine's
So
waiting.
she's been before the court and conditions have been set. Is that correct?
That's one of the.
So, ma'am, you're now formally charged with 1 count of assault in the 4th degree, domestic violence related. It's a gross misdemeanor, carries with it a maximum penalty of 364 days in jail and a $5,000 fine.
I think this is.
Did you wish to have me advise her formally of her rights, or are you waiving that?
We are waiving, Your Honor.
Okay. And then a plea of not guilty will be entered. This matter is going to get set for future hearing. We're going to give you a court date in just a moment. And then all conditions of release have been set. Those conditions will remain in place unless they wish to be addressed now. But otherwise, we'll see you back here on.
24th, 10 a.m.
Sounds good, Your Honor.
Yeah, give me just a minute here. June 24th at 10 a.m. And then, did you get a text reminder of this court date, ma'am?
Yes.
Okay. We'll print an order with a copy of your court date on it. You'll get a text reminder as well. And that'll be it for today.
Christine has her note paper ready and maybe a pencil.
Yeah, I can't.
But she's tired. I don't know how long Judge Boyd is going to be on break. It's been 52 minutes. This is a long break.
I'm sorry? Oh, of course, yes. Yeah, absolutely. Okay, no, I get it. That's fine. Yeah. You're always welcome up here, Mr. Gray. Don't worry about it.
I think these are all domestic violence charges.
Mm-hmm. Ma'am, one last thing, just make sure you communicate with your attorney before your next court date so there's a plan in place to how the case is going to be handled one way or the other. And you may go.
Thank you.
This quality, I don't think he understands because he's still here. He said yes, 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 but I mean that's. I hate that the criminal justice system will push people through if they say the right word, which is yes, which people.
Mr. Marembe, there's another arraignment.
Yes.
Are you prepared to do that on Ms. Shannon?
Mr. John Alonso, he's in court. He's right now.
Okay.
John Alonso.
Who's that? John Keyhofer? Yeah. Okay. And then, did you hear my question? Are you prepared to? You can come up, Mr. Keyhofer. We'll take yours now. And then Ms. Shannon's here for an arraignment also. Was that going to be one of yours?
Keyhofer?
Yes, I'll have to break up.
Okay, Mr. Keyhofer, you can go over there and take a seat.
We've seen him before.
So you're here on a criminal charge, on a charge of DUI. There's also a traffic infraction. Did you discuss with him his legal rights?
Yes, Your Honor.
Do you have any questions about any of those?
No, Your Honor.
Do you have a position on probable cause?
We're stipulating as to probable cause on.
So, Mr. Keyhofer, am I saying your name correctly, first of all?
Yeah.
Keyhofer, you're charged with 1 count of driving under the influence of alcohol and or drugs. That's a gross misdemeanor, which carries with it a maximum penalty of 364 days in jail and a $5,000 fine. Plea of not guilty will be entered. This matter will get set for future hearing. We're going to set conditions of release. I'm going to hear from the state on conditions, then I'll hear from Mr. Marembe. Is he requesting court-appointed counsel?
Yes, Your Honor, statutory.
I'll appoint Thurston County Public Defense to represent you. Mr. Clark.
Yes, Your Honor. Per my investigation into the NCIC, I believe this is a lifetime, but first in 7. So
were they from out of state? I don't see anything in.
One is from Whitman County. I'm not entirely sure what county that's a part of, but
Whitman County. I mean, is that in Washington State? I don't see anything on his DCH.
It doesn't know.
I'm sorry?
see any.
It is inside of Washington, but the NCIC I have says that this was a third and says that there was an offense in 2017 for DUI that was deferred prosecution.
In Washington?
Yes, Whitman County.
No,
I don't see that on jabs.
I didn't see that either.
No.
And Mr. Kihofers appears mystified.
Well, for right now, Your Honor, regardless, the state has no objection to a PR release with standard conditions.
Was there a BAC in this case?
Yes, Your Honor.
What was that?
It was.
Blood alcohol content?
0.104. Or 0.104.
That's high.
Okay, Mr. Kiofer, you're going to be released on your personal recognizance. Conditions of your continued release are: don't have any criminal law violations, don't drive without license or insurance, don't consume any alcohol or have any controlled substances out of valid prescription, don't refuse a breath test, and stay out of all bars and taverns. Your next court date's going to be
June 24th.
And so the state seems, did you say June 24th at what time? 8:30. June 24th at 8:30. They seem to think if they can confirm other convictions, they may readdress conditions of release at some point in the future. But for right now, those will be your conditions. Do you understand that?
Yes, sure.
And then Mr. Marembe, did you provide a cell phone for texting reminding purposes?
He just provided. I'm going to provide it.
Make sure it comes to the court. And then Ms. Myers, are you ready to go on the gentleman in the blue shirt next to you?
We have an interpreter.
Yes, Your Honor, I am.
And who is that?
Your Honor, this is Mr. Rodas. He's number 6 on today's calendar.
Okay, yes. And so your name is Domingo Rodas?
Señor, ¿usted el señor Domingo Miguel Rodas?
Sí, así es, correcto.
Yes, correct.
You're now charged with driving under the influence of alcohol and or drugs.
Señor, ¿tiene cargo por manejar bajo la influencia de alcohol o drogas?
Ms. Myers, did you discuss with him his legal rights, or do you wish to have me formally advise him?
Abogada Myers, ¿usted ya habló con él de sus derechos legales o quiere que yo hable de esto con él? ¿O ya se lo dijo usted?
Your Honor, I did advise him of his rights, and I do believe he understands them.
And
Yo ya, su señoría, le avisé de sus derechos legales y creo que los comprende.
Your Honor, we will not be contesting probable cause for the purposes of today's hearing and asking my office to be appointed.
No vamos a pelear la causa probable con propósito de la audiencia de hoy y estamos pidiendo que mi oficina sea puesta para representar al señor Rodas.
Okay, we waited an hour for Judge Boyd.
I will appoint Thurston County Public Defense to represent you.
Señor, voy a poner a los defensores del condado de Thurston para que lo representen.
A plea of not guilty will be entered.
Se va a entrar una declaración de no culpabilidad.
We're going to set conditions of release.
Vamos a poner las condiciones de libertad.
I'm going to hear from the state on conditions of release, and then I'll hear from Ms. Myers.
Primero le doy la palabra al fiscal sobre las condiciones de libertad y luego hablo su abogada, luego escucho su abogada. Abogado Myers, por favor.
Yes, Your Honor. The state is asking for $5,000 bail.
Sí, su señoría, el Estado está pidiendo $5,000 de fianza.
5 G's.
The state notes this is a 3rd and 7.
El Estado quiere anotar que este es el tercer caso.
And that this
Sorry,
is
for the 1 second for the interpreter. 3rd in 7 years.
3rd 7 years.
Okay, sorry about that. El Estado quiere anotar que este es el tercer caso en un periodo de 7 años.
The state also notes there is a dismissed case that is pending blood toxicology results.
El Estado también quiere anotar que existe un caso que ha sido retirado solo pendiente de que regrese el análisis del laboratorio de toxicología.
And finally, there is a former lifetime DUI from 2009.
Former lifetime? What?
Y también existe un anterior de DUI del 2009.
So at this time, the state requests $5,000 bail and heightened conditions.
Por lo tanto, el Estado pide $5,000 de fianza y condiciones elevadas.
Ms. Myers?
Abogada Myers.
Thank you, Your Honor. At this point in time, we would be asking that Mr. Rodas be released on his own personal recognizance.
Nosotros pedimos que el señor Rodas sea puesto en libertad bajo promesa de regresar.
It's important to note that this case is a blood draw. At this point in time, we have no results back.
Es importante decir que este caso está pendiente de los resultados del laboratorio y no tenemos resultados todavía.
I also would like to bring to the court's attention a few other things.
También me gustaría traer a la atención del tribunal otras cosas.
Mr. Rodas is diabetic and he needs to be out to take care of his diabetes as well as take the medication prescribed.
El señor Rodas es diabético, necesita salir para tomarse su medicación de diabetes y también la medicación que le es recetada.
He is receiving his medication while in custody. However, it is harder to take care of in custody than out.
Está recibiendo la medicación mientras está bajo custodia, pero es más difícil lidiar con este problema mientras está bajo custodia que si estuviera fuera.
In addition to that, Mr. Rodas has been going to Consejo for treatment.
El señor Rodas ha estado asistiendo a consejo para tratamiento.
I'm going to stop you there because he has the two DUIs that were referenced by the state were in the city of Lacey.
La voy a parar ahí porque él tiene dos de manejar bajo la influencia, así como ha hecho referencia el estado en la ciudad de Lacey.
I don't know why they're not on the Lacey calendar today.
Esto no está en el calendario de Lacey hoy.
They are for tomorrow on a
Están para mañana.
non-compliance. Sorry.
Están para mañana por no haber cumplido los términos.
The allegations of non-compliance are no treatment. So if he's in treatment, we're not getting reports.
Y las alegaciones de que no está cumpliendo es que no está recibiendo tratamiento. Entonces, si no tenemos el tratamiento, no tenemos los informes.
He also tested positive on Scram for alcohol on, that was received by the court on May 14th. And that was before the allegation of the DUI he's here for now.
Y también él dio positivo en mayo 14 para el alcohol. Y esto fue antes de las alegaciones por las que estamos aquí hoy en el tribunal.
I would note also that on that same DUI in August of 2025, the initial bail amount was $75,000.
También quiero anotar que ese otro DUI de agosto, la fianza inicial fue de $75,000.
And then the state is correct in the say second or third in the past 7 years, but it's also the third in the past 14 or 15 months.
Y el Estado está correcto en lo de decir segundo o tercero en los últimos 7 años, pero es que este también es el tercero en los últimos 14 o 15 meses.
But I apologize for interrupting you, and you may continue.
Disculpe por interrumpirla, usted puede seguir.
Your Honor, we would just ask that you give him the opportunity with the Scram monitoring device and heightened conditions to continue to proceed in his Lacey matters, continue in treatment, and then also be out of custody for the remainder of this case.
Pues, su señoría, le pedimos por favor que le dé la oportunidad con el monitoreo de Scram y las condiciones más atenuadas a seguir con los casos de Lacey que tiene pendientes, también a seguir con el tratamiento mientras está fuera de custodia y esto está pendiente.
He's on Scram now.
Él está bajo
So on Scram in the
monitoreo
jail?
ahora.
And he's still drinking as of last week.
Y como la semana pasada
That's not
estaba tomando.
And now we have a new allegation of DUI. So
Y
Scram
ahora
doesn't seem
tenemos,
to be working.
y ahora tenemos una alegación nueva de DUI, entonces parece que lo de Scram no está funcionando.
I appreciate that he has health challenges in terms of medication and treatment of diabetes.
Sí, entiendo que él tiene condiciones de salud para términos de medicación. Betis,
And that's unfortunate.
lo siento.
But he presents a much bigger danger to the public in that he won't or can't stop consuming alcohol and getting behind the wheel.
Pero él presenta un riesgo mucho más peligroso al público, ya que o no puede dejar de consumir alcohol y ponerse detrás de un volante.
He has 2 convictions for DUI since March of 2025, which is 14 months ago.
Tiene 2 condenas por DUI desde marzo del 2025, esto es hace 14 meses.
There was an allegation of another DUI, which was dismissed.
Existe otra alegación de DUI y esto fue retirado
Less than 2 months ago.
hace menos de meses.
He was, the Scram showed he was drinking within the past week.
El monitoreo Scrum muestra que estaba tomando en la última semana.
And now we have a new DUI alleged to have occurred, looks like on Friday.
Y ahora parece que tenemos uno nuevo que se alega de DUI que parece que sucedió el viernes.
I find that the danger presented to the public from Mr. Rodas far outweighs the medication or his treatment for diabetes.
Encuentro que el peligro que el señor Rodas representa al público es más grande que la medicación y su tratamiento de diabetes.
You yourself said he's getting medication there, although it makes it more difficult.
Usted acaba de decir que le están dando la medicación, que es más difícil.
Christine's going to fall asleep.
I'm not a doctor, but I got to believe that consumption of alcohol is not good for a diabetic patient.
Yo no soy doctor, pero quiero pensar que el consumir alcohol no es algo bueno para un paciente con diabetes.
I'm going to set bail in the amount of $100,000 cash or bonds.
Voy a ponerle fianza por $100,000 en efectivo o como por prestamista.
If it's posted, he's not to have any criminal law violations.
Si pone esa fianza, no puede tener ningún incumplimiento nuevo de ley.
Don't drive without license or insurance.
No puede manejar sin tener licencia válida y seguro para el vehículo.
Don't consume any alcohol or have any controlled substances as out of valid prescription.
No puede consumir nada de alcohol o tener ninguna sustancia controlada sin una receta válida.
Don't refuse a breath test if one is requested of you.
No puede rehusar hacerse una prueba de aliento si se le pide una.
Stay out of all bars and taverns.
Tiene que estar fuera de cualquier tipo de bar o taberna.
Any car he drives needs to be equipped with an ignition interlock device, which she'd probably have that now with 2 convictions from 2025.
Cualquier vehículo que maneje tiene que tener un aparato de arranque y esto ya seguramente lo debe de tener porque tiene 2 condenas del 2025.
He's also to report to pretrial services within 48 hours.
También tendría que reportarse con los de servicios anteriores al juicio, no más tarde de 48 horas.
Report to Friendship for the purpose of obtaining a biological alcohol monitoring device.
También reportarse con los de Friendship para obtener un monitoreo de alcohol biológico.
And UAs as directed.
y hacerse pruebas de orina así como se las indiquen.
He's on the calendar for post-disposition cases for Lacey tomorrow.
Está en el calendario para las disposiciones de ambos casos en Lacey mañana.
So you might want to let Pacific Point know where he is so they can get him on the in-custody calendar.
Quizás le quiera informar él a los de Pacific dónde se encuentra para que lo puedan poner o hacer aparecer en el calendario de Lacey de mañana.
If he can't make bail.
Y no puede poner fianza.
We'll set a pre-trial for May 26th, which is a week from tomorrow.
Vamos a poner una anterior al juicio para mayo 26, dentro de una semana.
We'll set it for 9 a.m.
A las 9 de la mañana.
But if he's still in custody at that time, that will need to be set over to 1:30.
Pero si está bajo custodia para esa fecha, tiene que ser pasado al calendario de la 1:30 de la tarde.
And again, the basis for such a high bail is the threat to public safety.
Y de nuevo, esta fianza tan alta es por el riesgo que él tiene a la seguridad pública.
And that's it for today. He can be taken back.
Eso es todo en el día de hoy. Gracias. Thank you, Judge. Can the interpreter be dismissed now?
Yes.
Can I be done?
Thank you. Bye-bye.
You did great, ma'am.
Are you ready to address Ms. Shannon?
I'm ready to address Mr. Carrie Devon. He's in court. He's currently in court. This is number 2 on today's calendar.
Shannon's just waiting forever.
And Your Honor.
Devon Carey?
Yes.
Okay.
And Your Honor, I'm meant to
Shannon's
understand
upset.
Ms. Christine Shannon does not qualify for court-appointed counsel according to the information that I have. She was on the calendar, but I think she was removed of the calendar for public.
Okay, so you're going to have to speak a little bit louder. I'm sorry.
I'm saying Ms. Christine, I think she's not, she doesn't qualify for court-appointed counsel. So she was on my calendar, but I think she has been removed. So
Public defense, I see public defense was added on last Friday or last week on the 13th.
It was removed, but I can address her. But I'll need a breakup
Okay.
room later. But right now,
Yeah,
Shannon's
no,
like,
it says
hey,
right here.
hey, right here, me.
Is
Let me
in
talk.
custody
Can I say
with
something?
Ms. Myers in front of me, and I appointed an attorney. I appointed your office.
It was removed.
By
It
who?
was removed. Is she going pro se?
So I didn't. So
but I
again,
can,
was that me who did that?
Your Honor, may I speak at all to you or just
Not
wait
right
my
now.
turn? Okay.
Just a minute, you will.
Yes, sir.
And Your Honor, I also remember this preliminary if I can be of any help too.
Yeah, well, just with the court of, just in terms of appointment, that I can't remember. I apologize.
We were not appointed, Your Honor. She does not qualify for public defense. And then
Okay.
I had addressed that I did advise that if she needs to petition the court for public defense at any point in time, she finds out that she could not afford counsel, then we would do it that way. But at the time, we were not appointed.
Okay. So, ma'am, I'll come back to you in a few minutes. But yes, I'll let you speak, but give me a few minutes here.
No
and Your
public
Honor, if
defender.
you want, we can. Mr. Carrie Devon is in.
Okay. So, actually, we'll take care of Ms. Myers's. Who's seated next to you up there, Ms. Myers?
Your Honor, this is Mr. Ewald. He's here for an arraignment hearing.
So your name is Danny Ewald,
Yes, Your Honor.
and then you're charged with 1 count of driving under the influence of alcohol. There's some infractions here too.
That's what they said, yes.
They are saying that.
Yep.
And Ms. Myers, do you have a position on probable cause?
Your Honor, we are contesting probable cause.
You say are or not?
We are.
Okay. Mr. Clark, could you raise your right hand, please? You swear and affirm the information and testimony you provide will be the truth, the whole truth, and nothing but the truth?
I do, Your Honor.
Go ahead.
Your Honor, I do believe this was a declaration was filed for this.
On the
for probable cause.
on
Oh wait, sorry. Wrong case.
I have to see what happens with Shannon before we go.
Yeah.
Oh, Mark Furman passed away.
On May 16th, 2026, about 2:37 a.m., Washington State Patrol Trooper Mira was traveling westbound on Martin Way when he observed a car traveling at about 75 miles per hour in a 35 mile per hour zone. He stopped him.
75 and a 35?
And contacted both occupants, one Logan Hamilton and the defendant. Mr. Hamilton was in the front right passenger seat. The defendant was in the rear right passenger seat. When asked why there was no driver, the defendant advised that Mr. Hamilton was the driver.
Take your time, sir.
One moment, Your Honor.
Shannon's like, I've got nowhere else to go. I'm just chilling here with my besties
While
from court.
speaking with the defendant, after ordering Mr. Hamilton out of the car, he observed gear in the driver's seat, which the defendant stated was his. He also observed a floor mat, and the driver's seat appeared to have fresh mud. In that time, while both shoes he observed the
Fresh
bottom of
mud?
both the defendant's shoe, Mr. Hamilton's shoe. The defendant's shoe was significantly more dirtier.
I think it was a beer, he said.
And at that time, the defendant refused field sobriety test. Upon explaining to the defendant the gap between his shoe being dirtier and the fresh marks on the floor, the defendant stated he did not know what happened. That is when the defendant was placed under arrest. At that time, he also had blood on his mouth from what he stated was a previous fight. He observed a small blood spot on the seatbelt, and at that time, the defendant was taken to the Capital Medical Center to provide a BAC, and the BAC at the lowest reading was 0.120. And those are the facts at this time, Your Honor.
Okay, so tell me again how they established he was the driver.
Your Honor,
there was
Your Honor,
mud?
they saw there was mud in the floor mat of the driver's seat. The defendant's shoes were dirtier than the purported driver, and then the officer also saw gear in the seat that the defendant stated was his, and finally he had blood around his mouth that he stated was from a fight he was in earlier, and at that time the officer observed what appeared to be a small blood spot on the seatbelt
Of the driver.
Of the driver's seat, Your Honor.
I'm not sure. Dismissed
Ms.
for
Myers?
probable cause.
Your Honor, There is no indication of Mr. Ewald being the driver. This sounds like a situation where we're grasping at mud straws to put Mr. Ewald behind the driver's seat.
Mud straws.
Mr. Ewald was in the back seat. He had a seatbelt on. There's no indication from this trooper that he saw any kind of movement from Mr. Ewald or any individual climbing into the back seat. Mr. Ewald is 5'11" and 215 pounds. There would be some kind of movement or indication that would be observable by an officer pulled behind the car, behind a stopped car, that he would be able to see an individual moving from the front seat to the back seat of a Jeep Grand Cherokee. That's not an enormously big vehicle. You would see movement. You would be able to see him through the windshield. At this point in time, the only indication that is giving the officer probable cause to believe that it was Mr. Ewald is that there was mud on the floor mats. The police report states that both Mr. Ewald and Mr. Hamilton had mud on their shoes. Mr. Ewald's shoes just appeared to be a little bit muddier, thus he was the driver, is what is being alleged by the officer. There is no commentation or comment on seeing any individual behind the driver's seat, what that individual looked like, what he observed from the driver. There is no comment on seeing anybody move from the driver's seat to the rear passenger seat. At this point in time, the only evidence here is mud on the floorboards.
When the officer came on the scene, what did he see? What was going on were everybody outside or what exactly?
No, Your Honor, he observed a vehicle traveling down westbound Martin Way.
Right.
Speeding, and when he attempted to stop the vehicle, there was a bit of lane travel, and then it slow rolled into a complete stop.
So did he? So he watched this happen, and then he came on the car. And what was happening in the car when he came on the car?
And when he came to the car, it was the defendant in the rear right passenger seat, and the Mr. Hamilton in the front right passenger seat, and
they were in the car.
They were in the car together. I will also note that it wasn't a little much dirtier. The officer stated that it's significantly more dirtier, but
the mud. As if all drivers get muddy? What? Dismiss for lack of probable cause, Your Honor. In the pursuit of justice.
Did the passenger have his or her seatbelt on, or could you tell? Or does it say?
One moment.
And you said there was blood on the seatbelt?
There was a small drop of blood on the seatbelt, Your Honor.
Okay. Any blood from the passenger? Any indication of that?
No, Your Honor.
Okay.
And Your Honor, I want to note that we have not seen the photo of blood at this point in time. I would be skeptical regarding what the small drop of blood on the seatbelt actually looks like or could appear as. As far as I'm concerned, it could just be additional dirt that has been noted as blood.
Okay.
And there's no indication of in either of the individuals wearing seatbelts, Your Honor.
Dismiss it. It's the right thing to do. In the pursuit of justice.
Also, Your Honor, my mistake. I did neglect to see this earlier. Mr. Hamilton advised that the defendant was indeed the one driving him from the bar, and that
the passenger.
Yes.
Okay.
And he was saying that the defendant was racing around town to find the person who hit him in the face.
All right.
In Your Honor, they said that about each other. One said the other was driving.
Okay. Well, I guess they're no longer going to be friends. But but based on what's been presented, either one of them had to have been driving. So one of them was either in the back seat, and then the driver moved from the driver's seat to the passenger, which makes less sense than the driver's seat, hightailing it into the back seat, and the passenger there is staying in the front seat. There is some corroborative evidence. Again, these are just, nothing's been proven beyond a reasonable doubt. These are just allegations. It is circumstantial evidence to be sure. about the mud on the shoes, but to be sure, there was mud on both shoes. There's indicated a bloody lip. I'm told there's evidence of blood on the driver's seat belt. I haven't seen it either. All I've known is what has been told to me in court. So I will find that probable cause exists for the case going forward, which again, doesn't mean it's been proven beyond a reasonable doubt. And so we're going to set a plea of not guilty will be entered. I will appoint Thurston County Public Defense to represent him. We're going to set conditions, and then I'm going to hear from the state.
Yes, Your Honor. The state will be asking for bail. The state will defer to the court an amount of bail in this case, but the defendant, this is a 2nd and 7 with a previous DUI from 2022 that was amended down to a reckless driving. So the state will be asking for bail along with heightened conditions.
Ms. Myers?
Your Honor, we're objecting to any amount of bail being imposed in this case. As it is, there is a lack of evidence. I think we barely crossed the threshold for probable cause. We have no objections to the ignition interlock device as it would be statutorily required. However, any bail in this case we believe would be tantamount to a no bail hold, as Mr. Ewald is not presently working. He has not worked in 2 years. Also, I based on the facts, we would ask for no bail to be imposed.
Mr. Ewald, I'm going to allow you to be released on your personal recognizance. Conditions of your continued release are: don't have any criminal law violations, don't drive without license or insurance, don't consume any alcohol or have any controlled substances out of valid prescription, they'll refuse a breath test, stay out of all bars and taverns. Any car you drive needs to be equipped with an ignition interlock device.
Expensive.
And then you're to report to pretrial services within 48 hours of right now. You're also to report to the Friendship Diversion Program, also within 48 hours of right now. And your next court date is going to be June 24th at 8:30. So do you hear what I'm saying and reporting to the Friendship Diversion Program for getting a scram device?
Yes, Your Honor.
And then Ms. Myers, did you provide a cell phone for
Your Honor, I am sending that right now, a cell phone number and an address.
and also make sure he has your office's phone number. You'll get released today. We'll see you back here on June 24th.
Thank you, Your Honor.
You're welcome.
Okay, we're waiting for Christine Shannon to get her day in court.
Carey?
She's been waiting quite patiently, and she also wants to talk to the judge.
So you are Devin Carey?
Yes, Your Honor.
It looks like you've been before the court. Conditions have been set. A plea of not, you're now charged with assault in the 4th degree domestic violence related, malicious mischief in the 3rd degree domestic violence related. Plea of not guilty will be entered. We're going to set a future hearing date, and then that'll be it for today. Your next court date is June 24th at 9:30. We'll print that for you, and then you can be on your way.
Thank you, Your Honor.
Your Honor, Your Honor, my client had an issue with the civil standby order. He has not been able to collect his personal effects because the accuser will not answer the door or the phone. So he's a little bit in dilemma. He doesn't know how to move. He has been asking for law enforcement to help him get some of his personal effects from the house, but he cannot.
You know, I think, Mr. Clark, I guess there's not much I can do about that, unfortunately. Yeah, you're just going to have to keep trying, I guess.
Oh, wow. That's
right.
awesome.
But that's it for today. We'll print that order. And then even though she's here for an arraignment, I'm still going to have you speak with Ms. Shannon,
All right.
just for the purposes of arraignment. And then Ms. Shannon, you're going to have you speak with an attorney. Then we'll come back for your arraignment. And then if you still have questions, you can ask them then. You said you wanted to speak to me earlier. Okay. Ms. Myers, who's seated next to you up there?
Your Honor, I'm here with Mr. Stowers. He is here for an arraignment here.
Shannon's like, can I go anytime soon?
You're Alafazio Stowers?
Yeah.
Shannon's sick of this.
Is that your name, sir?
Yes.
So you are charged with one count of driving under the influence of alcohol and/or drugs, one count of operating a motor vehicle without an ignition interlock device. Those are both gross misdemeanors. And then
Boyd is back.
I'm going to need a JNS for this case. There isn't one.
Let's do a quick check. See where she went.
Ms. Myers, you get a chance to speak with him regarding his legal rights?
I did, Your Honor, and I do believe he understands them as I've explained them to him. I would waive any formal reading. At this point in time, I would be asking for our office to be appointed.
I will appoint Thurston County Public Defense to represent you. Pleas of not guilty, you'll be entered to both counts. We're going to set conditions of release. I'm going to hear from the state, and then I'll hear from Ms. Myers.
Yes, Your Honor. State is
not back.
noting that the defendant has a previous case with us that is pending blood test, so it's currently dismissed, and a prior from 2012. So for those reasons, the state will be asking for tight conditions, but the state does not have objection to PR.
Ms. Myers.
Your Honor, we have no objections.
So, Mr. Stowers, you're going to be released on your personal recognizance. Did you hear? I don't have it. Okay. Yeah. Conditions of your continued release are going to be: you're not to have any criminal law violations. Don't drive without license or insurance. Don't consume any alcohol or have any controlled substances out of our prescription. Don't refuse a breath test. Stay out of all bars and taverns. Any car you drive needs to be equipped with an ignition interlock device. You're also to report to pretrial services within 48 hours of right now. You're also to report to the Friendship Diversion Program within 48 hours of right now for the purpose of getting a biological alcohol monitoring device and providing UAs as directed. Do you understand that?
Yeah. What was that second one?
Yeah.
The second one was the Friendship Diversion Program for get a biological alcohol monitoring device that's going to go on your ankle. You're going to get an order that releases you, and both those phone numbers will be on that order. And they need to take place within 48 hours.
All right.
Your next court date is going to be June 24th at 8:30.
All right. Can we please get Kristen on here, or Christine?
That's it for today.
It's not feeling good.
There's a David Moore on the calendar. What case are you here for? Or on the Zoom call, what case are you here for?
Your Honor, I believe he's a complaining party from the Foster case, I believe.
Okay, thank you.
Yes,
That's
sorry, my
helpful.
bad. I got it.
And Ms. Myers, who's seated next to you up there?
Your Honor, this is Miss Williams. She is number 11 and 12 on today's calendar.
Like, hey. I like that Miss Myers seems to know all her cases and get have good arguments for them. I mean, she's fighting for her clients every time she appears.
So in the case ending in 513, that's a preliminary appearance on a domestic violence related matter. What's the state seeking probable cause for there?
Violation of a no contact order, Your Honor.
And then on the other case, looks like she missed an arraignment. So first things first, ma'am, looks like Ms. Myers was appointed to represent you in the case ending in 327. So I'll appoint Thurston County Public Defense to represent you in 26 DV 0513 also. Do you have any comment as to probable cause on violation of a no contact order?
Your Honor, we're not going to be contesting probable cause for the purposes of today's hearing. At this point in time, too, I believe that we would be able to waive the arraignment hearing on this new matter so that we can continue tracking along with these two matters.
That's fine, but we'll still establish probable cause.
And we have no objections. We're not contesting.
So I'll find probable cause for violation of a no contact order. We're going to set conditions of release on that. Then we're going to set court dates on both of these. And again, waiver of arraignment. We'll just proceed straight to pretrial then. Give me just a minute. So, Mr. Clark, what's the state's position on conditions of release?
Yes, Your Honor, they will be asking for $2,500.
Only
bail
Funsies just gifted 10 memberships.
Case, along with the no contact order, no new law violations, and no firearms or dangerous weapons. The state notes that the defendant was just charged with assault with the same victim in last month in March, the previous case we were discussing. And based upon that, the state is asking for $2,500 bail in that case as well, and making an oral motion to revoke the conditions of release for that March case. The case ending in 327.
Ms. Myers?
Your Honor, we would be objecting to bail in any amount. First of all, I don't believe that there's any conditions to revoke in the previous case. She had a warrant in the matter. In addition, she's only 18 years old. I think where we find ourselves right now is that Miss Williams is being heavily affected by a lack of resources. She's been out on her own for 2 years. She does not have any stable housing. She does not have any stable support. Before the last court date that she had missed, she had recently been put up in a hotel room and had been advised of how to get in contact with DSHS and all of the services that they would be able to provide to her, such as EBT, helping her get identification and other benefits. She has some mental health issues on top of everything that she's dealing with of being out on her own. Things just kind of stacked up onto her plate. And being 18 years old, that's a lot to be dealing with if you're suffering from housing insecurities. So, unfortunately, her failure to appear was just a matter of being overwhelmed and trying to figure her way out. Now that we're back in contact and my office is appointed, I have given her the contact information to Miss Candace Garman, who is our social service worker, who will be able to provide her with a steady support system, and will be able to get her in contact with everybody who she needs to that can help her find housing, employment, and other benefits that can assist her. Given how young she is, her lack of criminal history, the one warrant that we have seen of this matter, we would be asking the court to PR her to allow her to work with my office so that we can provide her some kind of stability.
Give me a minute.
Judge is thinking this one over.
Okay. All right, on, so ma'am, I've reviewed the probable cause statements in these cases. I mean, do you have any place to go besides your boyfriend's? It sounds like you're living with your boyfriend there, or at least staying there, and then things got sideways between you and your boyfriend's father and all that. You don't need to comment on that. My question is, do you have any other place to go?
I have my mom. She can pick me up. She'll let me stay for a day or two, and then I have a friend that I was staying with that I can stay with her longer in Lacey.
It's not a very
Right,
long-term
so
secure situation.
I'm not going to set, again, you don't have anything else on your record. It looks like, the allegations, Lisa started as invited contact. You need to understand that even if you have a no contact order, you're not to have any contact with this person. Do you understand that?
Yes.
Even if he calls you and tells you, hey, come on over, all is forgiven, that's a problem. If you get caught there, you're going to jail. Do you understand that?
Yes, sir.
And so I'm not going to set bail on you at this time. But if this keeps happening, then eventually we'll get there. Do you understand that?
Yes, sir.
On the new, all prior conditions remain on the old charge. On the new charge, the conditions of release are: don't have any criminal law violations, don't possess a firearm, comply with any existing no contact order. I'm not doing a new no contact order, but that old one's still in place. Your next court date is going to be? No, she's waiving the arraignment, so we'll just set pretrial on both these. June 24th at 9:30, and speedy trial will run 90 days from right now on both of these cases, given that you're waiving arraignment and we're setting conditions. You agree with that, Ms. Myers?
I do, Your Honor.
All right. So that's it, ma'am. Again, it sounds like you're in a tough spot right now, but I think we can all agree you're very young, but conduct yourselves in a manner that provides you don't go back to where you're at right now. Do you understand that?
Yes, sir, I do.
I hope so. You said June 24th at 10, right?
9:30.
What'd you say?
9:30.
I don't even want to be locked.
Where did Christine go? We figured out that Judge Boyd is just gone for the day. If she did come back, she didn't come back to us. So we're planning on finishing out this case.
That's it for today, ma'am. You can be taken back.
Thank you.
If she just doesn't come back, our plans to look at
What's your
Paul
name?
Canero.
Are you here for?
Sentencing and Tyler Robinson hearing tomorrow, which were pool media.
We've already dealt with that case.
When I first got here, they didn't go over it yet.
Yeah, they did. He was released, but a no contact order was entered.
And I
Not now. I mean, we're done. We're not going to do anything without everybody present. And so, hang on just a minute. We did a civil standby in that case, didn't we? A civil standby was allowed where he can come with law enforcement to get things, but that's it. I don't want to go any further than that.
Okay. Is there any possibility for me to dispute the no contact?
Well, at some point in the future, yes, you can ask to rescind it, but I'm not going to do anything when not everybody's here. You understand what I mean?
I'm just wondering, how do I get that in place?
You can, there's a desk outside. You can go to the window. You can talk about a motion to rescind the no contact order.
Okay, thank you.
You're welcome. Ms. Myers, who's seated next to you?
Your Honor, I'm here with Miss Foster. And to note that Mr. David Moore, who is the complaining witness in this matter, is also present on Zoom.
All right, give me a minute.
Fine, Mr. Moore. Judge is reading everything. Rain all day and a killer headache. I'm sorry. That's no fun. Well, the one thing about being on Zoom court, you can subpoena all the footage and get your selfies for social media off of that if you look good. Stacey Ray, I'm sorry, no jury duty for you.
Okay. So what's the state seeking probable cause for?
Your Honor, state seeking probable cause for assault for and interfering with reporting.
What?
So Ms. Myers, you get a chance to speak with Ms. Foster regarding her legal rights?
I did, Your Honor, and I did advise her of those rights. I do believe she understands them as I've explained them to her. At this point in time, we will be reserving any argument on probable cause and asking for my office to be appointed.
I'll find probable cause based on the PC statement that was submitted. I will appoint Thurston County Public Defense to represent you, ma'am. I'm finding probable cause for assault in the 4th degree and interfering with the reporting of domestic violence, at least one of which is a gross misdemeanor, carries with it a maximum penalty of 364 days in jail and a $5,000 fine. We're going to set conditions of release. We're also going to set an arraignment date 3 days from today. And I'll hear from the state on conditions. Then I'll hear from Ms. Myers. Mr. Moore is on the Zoom call.
Correct, Your Honor, and the state anticipates that he will tell the court that he does not want a no contact order, but the state will be seeking one in addition to the conditions of no new law violations and no firearms, dangerous weapons. And the state will not have any objection to a personal cognizance release.
Mr. Moore, can you unmute and come on the Zoom call, please?
Yes.
You wish to be heard on this?
Yes. Yes, Your Honor.
Go ahead.
I don't think that she needs a no contact order. She's very she's not a threat. She's very gentle, good person. And I would like it dropped, the case. That's all I have to say.
Ms. Myers?
Thank you, Your Honor. We have no objections to the conditions except as to the no contact order. We would be requesting that no contact order be imposed. This is the first of any type of allegation that Ms. Foster has. This is the first of anything on her criminal history. She's only 22 years old, and it sounds like this was stemming from drinking. The allegations were stemming from drinking. At this point in time, in lieu of a no contact order, defense proposes that Ms. Foster be subjected to no alcohol or non-prescription drugs, and she would be amenable to doing random UAs if it meant no contact order be in place. I do believe that this would be a resolution to not having a no contact order, especially if the allegations are stemming from a time when they were both engaged in drinking.
Let's not do any drinking anymore.
Did you talk with her about Scram?
I did not, Your Honor. We just only spoke about UAs.
Well, when I ask her, you can go ahead and mute, ask her what she thinks about that.
The case is not going to go anywhere because the complaining witness
Your
is
Honor,
not wanting
we
to participate.
are okay with Scram instead of the UAs.
Are you working right now, ma'am? Mr. Moore, you can stay on the camera.
Oh, Christine's back.
Is she working, Ms. Myers?
Your Honor, she presently lives with her mother.
Okay, so they don't live together?
They do not.
I see. Give me just a second. So, ma'am, you're going to be released on your personal recognizance. Conditions of your continued release are: don't have any criminal law violations, don't possess a firearm or other deadly weapon. You're not to consume any alcohol or have any controlled substances out of valid prescription. Don't refuse a breath test. Stay out of all bars and taverns. Heard what Mr. Moore has had to say. So I'm going to require that you report to pretrial services within 48 hours of right now. You're to report to the Friendship Diversion Program within 48 hours of right now. And you're also to get a biological alcohol monitoring device, which is a bracelet that's going to go on your ankle to make sure you don't consume any alcohol. There's reference in the police reports to other episodes of alcohol consumption, which by itself is not illegal, but if it leads to illegal activity, that's kind of a problem. It strikes me that you have kind of a problem. And so if there's any violations of the SCRAM device, so I won't order a no contact order. I tend to agree with Mr. Moore that this looks like this was instigated and fueled by alcohol. And so, yeah, you need to be back here in 3 days on May 21st at 1:30. You can zoom in, and you need to have the SCRAM device installed by then. Do you understand all that?
Yes, sir.
And if there's any violations of that SCRAM, like you test positive for alcohol, then they'll be back here. Then we'll be talking about bail and hanging on to you in addition to the no contact order. Do you understand that?
Yes, sir.
So no drinking from this point forward till the judge says otherwise.
Yes.
And this is not part of the court order, Mr. Moore, but it'd be a great idea for you not to consume any alcohol either, especially when you're around her.
I like that.
Yes, sir.
If you mean what you say, you're going to make every effort to not get her in any more trouble. She's in some trouble right now. All right. That's it for today. We'll see you back here in 3 days, ma'am.
Boyd is not coming back tonight. Okay, Christine, you've waited patiently. You were here the whole time through this whole block. Do you get to talk to the judge finally and explain why you don't have public defender anymore?
And then Ms. Shannon, can you unmute, please?
There we go.
Yes, sir.
So you're here for an arraignment. And then, Mr. Marembe, I appreciate that public defense isn't appointed right now, but for the purposes of arraignment, we'll go forward. And then, so does she wish to readdress appointed counsel now, or is you going to hire an attorney?
She says she'll have to hire private attorney going forward, but for today's purposes, I'll be represented.
So you're going to hire someone, ma'am?
Yes, sir. I was in the midst of it and it kind of fell through. I admitted myself to rehab as soon as I got out of jail. So,
I see.
Yeah.
How long?
It made it tricky.
How long are you going to be in rehab?
I'm going to be doing the residential stay, so it'll be a month.
Are you working? Does this affect your income?
Yes. I have taken FMLA.
Family Medical
It will,
Leave
but I
Act.
have an appropriate amount of savings.
Okay. Because if you wish to be rescreened for court-appointed counsel, we can do that. But if you don't want to, you don't have to. Are you calling from the facility right now?
Yes, sir.
All right. Plea, you're now formally charged with 1 count of assault in the 4th degree, domestic violence related. A plea of not guilty will be entered. This matter will get set for future hearing. When did you go in? You've been in since when?
I can't even remember the exact date. May 13th.
Okay. So if we set this for like June 24th or something like that, you'll be out?
Yes, sir.
All right. So a plea of not guilty will be entered. All prior conditions remain, including, I think, a no contact order.
Yes, sir.
And your next court date's going to be June 24th at 9:30.
Okay.
And then, yeah, if you hire an attorney by then, it would be great. Let him or her know about letting us know. And then if for whatever reason you have to stay there longer, just let us know, all right? We'll give you.
Absolutely. I appreciate I appreciate you working with me.
That's it for today, ma'am. You're free to go.
Okay. Thank
We'll see
you.
back
Have a
here
good
on
day,
the 24th.
sir.
You're welcome.
All right. Thank you.
All right, we're going to bail from that. We're done for today. Judge has not come back. If she did resume court, she didn't resume the live stream. So we are stuck like Chuck. And here are the plans for tomorrow. Paul Canero is getting sentenced. He's the one that is accused of shooting and killing his brother in his brother's yard. Remember the whole cut the power. He went out to check the power, shot him there, then went in the house and killed the wife and the kids in the house. It was both pew-pew and stabby involved there. Then lit that house on fire, burned that house down, drove back to his house, lit his house on fire. You're going to remember this case. Well, his sentence is tomorrow. And we also have a hearing for Tyler Robinson out of Utah County in Utah. That's with Attorney Nestor again. And so we'll see her again. Yes, for sure. So some stuff on the schedule tomorrow. We're also going to keep an eye out for, did Judge Boyd go to that funeral for the other attorney? Was that tonight, Shelley? That would explain the delay. She must be frustrated. She told this jury they'd be done by Friday. They are not done. Not yet. So, Shelley, that might be it. I forget what the date was.
When we started 110 years ago?
Yes, you guys both put this command up at the same time. That was funny. All right. That's it. Whoa. That's the wrong button. I'm sorry. That was not it.
That's not him.
That's not it either. This is it. All right, I'm sorry. So many buttons, so little time. We're going to wrap it up for today. Y'all get to take the rest of the evening off. It is 6 o'clock here on the East Coast anyway, so you put in a full day of work. Appreciate it.
A squirrel finds a nut once in a while.
Even a blind squirrel, yeah. All right, let's go have a great evening. It is Monday. Tomorrow's Tuesday. We're kicking off the weekend style. Hopefully your Monday was not terrible. Right? I realize it's tough to go back to work on a Monday after a nice, wonderful weekend. But hopefully your Monday was not terrible. And if it was, I hope Tuesday is better. So tonight when you go home, please hug the people you love, smile at someone, make their day just a little bit better. And please stay safe till we go live again tomorrow morning with some great hearings, sentencing hearings, and Tyler Robinson hearing, and maybe Judge Boyd. We'll see what happens. We'll play it by ear. Y'all be good to each other. We'll see you in the morning. Have a good one. Sorry, Josh. Got feeling better, all right, man? I'll turn the music up just for you. Sorry.
You don't put a diplomatic plate on a hoopty.
There's nothing in the order that restrains you from talking to cats.
What more do you need to see?
It's bigger than you. It's bigger than me. It's bigger than all of us.